I would like to mention the application, my lord. Claim application.
Yes.
Application.
My lord, may I be permitted to mention one matter, my lord, item number 175.
Yes, item.
Item number 175. Very short point is involved, my lord. Lordship may kindly fix any day, 175. Both sides are present. 175. Any day, your lordship.
So it's a 2025 matter.
Yes,
What is
my
the
lord.
urgency?
Very short point is involved.
Okay, let it appear as to be mentioned
Lordship.
on Monday.
Lordship, I'm grateful.
With your lordship's leave, my lord, if I may mention, my lord, this matter, my lord, had been taken up, my lord, on the 26th November, my lord. This is an appeal, my lord, against an order passed by the Railways Claims Tribunal. Now, my lord, this matter, my lord, was made returnable on the 27th of January, my lord. Since it was not in the list, my lord,
It was hard. The matter was hard.
no, my lord, it didn't come up in the list, my lord, and that's why I had mentioned.
Let it appear as to be mentioned first.
My lord, your lordship had directed the matter to come up as to be mentioned yesterday, my lord. It was again not called, my lord.
The file is here. It will appear to be mentioned tomorrow.
Yes, my lord. The only difficulty, my lord, is that the interim order is expiring tomorrow, my lord.
Anyway, yes, put it up tomorrow.
Your lordship, I'm mentioning for application in connection with second appeal, your lordship,
Yes.
on inclusion.
Yes.
For the correction of a order, my lord.
To be mentioned, yes.
Ready hearing.
Inform the opposite party.
Ready hearing, but 2014 appeal. Ready hearing.
Yes, give it.
I'm not on
To be
appeal.
mentioned.
My lord. On appeal, but 2011 appeal. But still, my defamatory number has not been allotted. Instead several direction by the court and depositor is still a messenger.
Anyway, let it appear as to be mentioned first.
My lord, please to mention two matter for correction.
Yes, to be mentioned.
My lord, item number 64. The only point is the OP1 directed the tribunal to pay the OP1, but it will be OP2. Only this very short point, my lord. Any date will be fixed for it. There is a 170, they filed everything. 64, my
Let
lord.
it appear as to be mentioned on Monday.
Monday. Right. And my lord, another thing, two judgment was pending, 17/11/25. Judgment.
11, it was fixed for judgment.
Yes, my lord.
Let me see the order.
Another is 5/1/26. Two judgments were pending.
Let me see. 17/11, it was fixed for judgment.
Fixed for judgment, no, the hard on that day. And
It
25,
was CLB or it was fixed for judgment.
I don't know, my lord. 17/11/25. Matter was hard by your lordships.
Okay. This one. This one was hard on 5/1/2026. Anyway, it will also be delivered in due course. এটা দিয়ে দেবেন কালকে এটা দেখি আপনি জাস্ট আগেরটা
64.
হ্যাঁ সম্ভবত yes was that related to any injury case?
Yes.
এটা দিয়ে দেবেন কালকে জাজমেন্ট এটা আমি ঠিকই করে রেখে কালকে জাজমেন্ট দেবো বলে ঠিক আছে এবারে আমি দেখছি এবারে আমি ডেটে বলে দেবো কোন ডেটে অ্যাপ্লিকেশন হবে কোন ডেটে হিয়ারিং হবে নির্দিষ্ট করে দেওয়া হবে এবার তাহলে কোনো মামলা হবে না আচ্ছা আর ওইটা ঠিক আছে ডিউ কোর্সে হবে আর ওটা যেটা আছে 17/11 ওটা কালকে দিয়ে দেবে যেটা 17/11-তে
Application, actually, during the pendency of the case, one of the appellant died.
yes it will appear
May I have my lord's kind leave to me?
yes
With regard to item number 82, lordship kindly remember on the opening, my lord is listed on top. My lord, your lordship could not be
who is appearing for the other side
on your part, my lord. And my lord, on Monday it appears. Tuesday it appeared, adjournment. My lord,
just wait
my lord, it appears to be made.
on Monday I shall see on Monday I shall see okay
My lord, Monday, your lordship Monday let it appear as to be made.
item number 82 to be mentioned on Monday.
May I have my lord's kind leave to mention one second appeal, my lord?
Second appeal?
Second appeal, my lord.
It is ready for hearing or application?
Yes, it is ready for hearing.
Yes, give it to be mentioned.
My lord, may I be permitted to mention, my lord, I am praying for application in connected with admitted second appeal, lordship.
Yes, give it.
Grateful, lordship.
Sub notice also upon the opposite party.
Lordship.
Objection, Lordship. Mr. Somando Ganguly appearing on behalf of the appellant, Lordship. Lordship, very short point, Lordship. Income point, Lordship. And the Lordship fix,
Okay, to be mentioned Monday.
Lordship, much obliged. And Lordship, one more, Lordship, kindly inclusion in the list, Lordship.
Yes,
Lordship.
to be mentioned.
My lord, I was humbly praying for your lordship's leave, my lord, for listing of this application, my lord, insurance companies, my lord, for listing before your lordship.
Yes.
My lord, the difficulty what I face, my lord, the execution case is fixed, my lord, on the day after. Lordship, kindly, my lord, direct the matter to appear tomorrow, my lord. That's to be mentioned.
Record is here, it will appear tomorrow.
Lordship,
আচ্ছা,
hey, সঙ্গে এটা কালকে,
এই দেখুন এটা রেকর্ডটা
my lord, for listing is to be mentioned tomorrow, my lord.
দিয়ে দেবেন, রেকর্ডটা থাকলেই কালকে দিয়ে দেবেন।
My lord, may I permitted to mention the
Grateful to your lordship.
section under to be mentioned, my lord.
Which case? Claim case?
Matter, sir.
Claim case which year?
2024 matter. Paperbook.
Yes, to be
printed,
mentioned.
my lord.
Item number 8.
Yes, item 8.
I'm very not pass over your lord.
Okay, let it be not this week.
Much obliged.
Yes, call 9.
Item 9, I have the petitioner. My instruction is to withdraw this application.
Yes, record and order. You are for the Appellant Union of India. Okay, M.S. Sapurna Banerjee, learned advocate, appearing for the Appellant Union of India, submits that he has instruction to withdraw this appeal. In the facts and circumstances, this appeal stands dismissed for non-prosecution. Interim orders, if any, stands vacated. Let the copy of the instruction filed be kept with the record.
Well, I am for the appeal.
My lord, I am for the respondent insurance company.
The old appeal, my lord, day before yesterday, I could not appear, my lord, in the first item of the appeal. It fixed at first item. At
So,
10:30,
item
I
number
could-
10.
I not ten.
Item number 10, it is ready for hearing.
Happened.
My lord, it's ready for hearing. It may be fixed on Monday, my lord, at 10:30.
I could not appear on all day before yesterday.
আচ্ছা সোমবারে কি কিছু ফিক্সড আছে দেখুন তো আর 10:30
Monday or Tuesday.
না সোমবারে 10:30 কটা আছে এমএসসি থেকে একটা আচ্ছা ইয়েস না 10:30 এমএসসি নয় ইয়েস রেকর্ড অ্যান্ড অর্ডার let this matter appear on 2nd February 2026 at 10:30 a.m.
I'm grateful, my lord.
Lordship, I declare on behalf of the appellant, Mr. Shivendranath Narayan Shukla is appearing in this matter on behalf of the appellant, Your Lordship. Your Lordship has already heard this matter substantially.
Lordship, I was to make my arguments, Your Lordship.
We have not yet concluded the
So let this matter be fixed next
On a-
week.
on a day, any date after 3rd of February.
So on the next, we will
Lordship,
make
any-
decisions.
No, Your Lordship, I did not make my submission. He is to complete first, and then I will make my
Yes,
submission.
record an order. Learned advocates for the parties are present. As this matter was earlier heard, let this matter appear on. Next week ये देखो तो ये कत तारीखे আছে কি
Lordship, could it be after the 11th of February, Your Lordship?
আচ্ছা 11 তারিখে 12 তারিখে দেখুন তো কিছু ফিক্সড আছে হ্যাঁ না 12 তারিখ বৃহস্পতিবার আছে let this matter appear on 12/2/2026 at 2 p.m.
Grateful to Your Lordship. At item 12, I'm for the Appellate Union of India. Well, same instruction.
Also same prayer.
Yes, same.
Yes, record an order. আইটেম 9 এ যে অর্ডারটা আছে না ওইটাই দিয়ে দেবেন
Yes,
সেম অর্ডার ওকে Item 13, yes, not this week. Yes, not this week.
This appeal has come at my instance for correction of the order. Kindly see the award passed by your lordship on 22nd January 2026.
What is the correction?
Correction, my lord, in the top, my lord, there is no, my lord, mention of my lord court. Court is the court 59.
There is a mistake in the cost title.
Court 59 of 2000, Court 59 of 2024. And appearance.
The operative portion, it is there. In the operative portion, there is an observation that both are disposed.
Both are disposed of, but in the cost title, my lord, in the head, my
Yes, yes, in the cost title, it has to be incorporated.
yeah, one thing, my lord. Secondly, my lord Taposh Ghosh and my lord Tanmay Karmakar, Tanmay Chaudhuri appears with me, my lord. Their names are not, my lord, mentioned in the order sheet. That is there.
Your name is there.
Yes. And third, my lord, and third, my lord, here, my lord, the court, my lord, I have preferred the court. Your lordship dismiss the court. But my lord, one thing I should, my lord, being an officer, my lord, being a learned advocate, here the tribunal granted on Soterium only 25,000 and funeral expenses 10,000. But no loss of estate.
Anyway, I have considered that. With regard to the merit,
You have not considered.
maybe it is, I have considered as a whole, and
My lord, your lordship mentioned.
no,
My lord,
I have considered entire thing and thought it just and reasonable.
my
That's
lord,
why entire,
Pranay Shetty says.
whatever it is, I have considered entire thing, okay?
Pranay Shetty judgments, my lord, has one specifically said.
Very well, there are so many cases, you see.
my lord,
I have heard it on merits, I have given my reasons, okay? Now, there is no scope to reopen that issue again. Yes, record an order.
Add, my lord, only 15,000, my lord, cannot be added.
Whatever is done, then you go higher up, get it reversed from the apex court. That is all remedy.
My lord, once your lordship dictates this order, my lord, certain more corrections have to be added, my lord, which we have missed out not at the time of disposal.
Then you come with an application.
No,
it
my
will
lord,
be better.
my lord, the correction, my lord, your lordship will kindly see. My lord, kindly have a look at this, my lord. My lord has dismissed, my lord, the appeal as well as the cross objection.
Yes.
My lord, your lordship will kindly see, my lord, the award passed by the tribunal, my lord, was 69,23,000 with 6% interest.
Yes.
My lord, insurance company has deposited, my lord, 69,13,000 before this honorable court.
Yes.
My lord, this deposit is 10,000 rupees less.
Okay.
And my lord, my lord, interest has not been deposited. My lord, it was indicated to your lordship, my lord, perhaps my lord, we missed out or it didn't go.
6% interest was awarded.
6% interest was awarded by the tribunal. They are entitled to get.
Yes, yes, yes.
But my lord, what had happened, my lord, when I deposited this money in High Court, my
Yes,
client,
yes.
my lord, we did not deposit the interest. They are entitled to interest, my lord. My lord, I have also deposited 10,000 rupees less. I have indicated to your lordship. So, my lordship will kindly see, my lord, the written part. Now, in view of the dismissal of the appeal and cross objection, insurance company is to deposit rupees 10,000, which is deposited less, plus 6% interest on the total compensation amount to be calculated from the date of filing of claim application till the date of respective deposits, because deposits were made on different dates. By 10 weeks from the date of communication of this order, such deposit is to be made by a check issued in favor of Registrar General High Court, Calcutta. My lord, I would be paying them more. My lord, they should not get less. So, my lord, this should
I'll
be
clarify. That will be clarified.
my lord, your lordship will kindly, my lord, add this part, my lord, so that, my lord, they get the appropriate amount and my client deposits more money.
For an order.
I'm grateful to your
Learned
lordship.
advocates for the parties are present. The matter is put up for necessary rectification of the order dated January 22, 2026. Passed in January 22, 2026. It appears, it is pointed out that COT
COD 59 2024.
COT 59 of 2024 is not mentioned in the cause title. Thus, the same be mentioned in the cause title of or judgment dated January 22, 2026. The name of the learned advocates not recorded on the said date.
Taposh Ghosh and Tanmoy Choudhury.
Taposh Ghosh and Tanmoy Choudhury be recorded as learned advocates for respondent number 1.
Respondent number 1 and 2.
1 and 2. Mr. Singh submits that at the time of making the deposit, when the appeal was admitted, rupees 10,000 less was deposited and leave be granted to deposit the deficit amount. In view of such submission, the appellant insurance company is permitted to deposit the deficit amount along with interest at the rate of 6% per annum from the date of filing of the claim application till the date of respective deposits within a period of 8 weeks.
Not 8 weeks from the date of communication.
8 weeks from the date of communication of this order.
My lord,
One thing, my lord, the deposits, my lord, with accrued interest. That would not be picture.
That is already there.
Oh, my.
Oh, has any case, has any occasion come that
We approach my lord before the learned Registrar General. My lord, learned Registrar General, my lord, the office.
Acha, other content.
my lord,
of
your
the
lordship,
order-
it is there, the very last page of the order. The respondent number 1 and 2 claimants are permitted to withdraw the awarded sum deposited along with interest accrued upon. What is he asking?
Yes, my lord, the 10,000, my lord, along with 6% interest.
My lord, your lordship, my lord, may I indicate
Yes,
one thing, my lord? My lord,
6% interest. This is not yet deposited. How it will accrue interest?
my lord, my lordship, I missed out one thing.
Mr. Singh will deposit with
My
interest.
lord, I will deposit 10,000 and my lord, I will also deposit interest on the principal sum what I have already deposited because I had not deposited interest earlier. Lordship will ask me, my client, to deposit interest on the already deposited amount.
From the date of till the date of respective deposit.
My lord, your lordship will add clarify. एक मिनट बोलते दाओ ना यार. My lord, your lordship clarify insurance company has not deposited any interest.
As it is also submitted that insurance voter body insurance
favorable
company
কি
has
তাতে
not
তুমি জ্ঞান জ্ঞান
deposited the interest. Let the said interest be also deposited
Grateful to your
in
lord.
accordance with the order of the learned trial court.
Obliged to my lord.
তারপরে যা আছে such deposit be made.
আমার ফেভারে কথা বলছি তাতেও জ্ঞান জ্ঞান
The inquiry from the date of filing of the claim application, the date of.
Yes, Mr. Singh has.
Lord, I have myself come up. Obliged to your lordship.
The other contents remain unaltered.
Grateful to my lord.
My lord, I appear for the appellant. The matter is appearing at my instance. There was it. How it was not appearing in the list, my lord. My lord, may kindly fix it on the 4th or 5th of February. I'm being led by Mr.
Mr. Hard earlier. Or
Yeah, Lordship, Mr. Mukherjee was addressing my lord.
Yes, record an order. Learned advocates for the, you're for the appellant
Yes, my lord.
is present. As this matter was heard here earlier, let this matter appear on. আচ্ছা এটা দেখুন তো একটু এই কালকে ওই অনিরুদ্ধ বাবু আর ওই প্রবাল মুখার্জির ওই কেসটা কবে দেওয়া হয়েছে? না না ওটাই হিয়ারিং এর একটা ফিক্স, ওই যে প্রবাল মুখার্জি আর ওই অনিরুদ্ধ বাবুর ওটা হ্যাঁ
বলেছি।
ওটা কবে ছিল? 2 তারিখে দেওয়া আছে কি 3টের সময় না 2টোয়? 3টে দেওয়া আছে। Anyway, I'm keeping it at 3 p.m. on 2nd
Fine.
because another case of Mr. Mukherjee is also fixed on that day.
He may not, if I recollect, may not correct, may not, he had said that he would take another 45 minutes to may not conclude. May not, Mr. Mukherjee had also requested him to keep it either on the 4th or the 5th, if your lordship's diary permits.
আচ্ছা 4th 5th এ কি আছে? Okay, let it be on 2nd. Thereafter I shall fix the date.
Fine.
On
Second at 2 p.m.
3 p.m.
3
The earlier case, another case is at 3 p.m.
Welcome.
So there on that day I shall decide
I'm grateful.
As of now, it is being fixed on the 2nd
at 3 p.m.
for hearing.
My lord, I appear for the appellant, my lord. Lord, the incident took place, my lord, on 2/9/2003. And my lord, order of the tribunal was passed on 28th August.
This is what claim case.
Claim case, my lord.
Who is appearing for the
My lord, Mr. Rajesh Singh.
But I'm for the respondent.
হ্যাঁ ফার্স্ট ভলিউম আমার কাছে তো একটাই ভলিউম আছে, ও সেকেন্ড ভলিউমটা বোধহয় কপি দেয়নি
কি আছে সেকেন্ড ভলিউম তো নেই কি?
আমার কাছেও তো নেই। ওটা আমাদের ডিপার্টমেন্ট থেকে দেয়নি। হ্যাঁ 292।
292 আপনার কাছে কি আছে? আমার কাছে দাদা এটাই তোমার কাছে আছে?
আমারটাই তো আমি তোমাকে জেরক্স করে দিচ্ছি।
একটা মামলার পরেই হবে তো।
লাস্ট পেজ কত?
Same.
anyway it was heard by the division bench earlier.
Yes, my lord. That was a
Yes, what is the ground of challenge?
my lord ground of challenge. If I place before your lordship, actually before that, my lord, may I submit before your lordship that this order was passed by the tribunal in 2009, and my lord, there, my lord, the award was 1,54,000 something, my lord.
See, this is a injury case.
My lord, this is a death case, my lord.
Now let me see, 163A or 166?
No, 166, my lord.
166.
166,
So what is your ground of challenge?
my lord. Actually, the compensation which was awarded, my lord, that was not just and reasonable, and my lord, without following, my lord, the guidelines of the Honorable Supreme Court, the learned judge, lump sum has been awarded 1,54,000. That your lordship kindly come to page, my lord. My lord, page 103.
Yes.
My lord, at the penultimate paragraph, your lordship would found
Yes, 1,54,000.
the petitioner do get an award of compensation of rupees 1,54,500, and after deduction of 50,000, which has already been paid in connection with another proceeding, he is hereby directed to pay the aforesaid amounts and so 1,04,500. Too meager amount, my lord, which was, my lord, considered.
Age of the victim was?
Age of the victim was 13. He was a student of class 9. He is an exceptionally brilliant student, my lord. He participated in the business of the, my lord, the father's business. My lord, he was an income tax payee, and his last income was 46,000 something, my lord, which was written in the judgment, but nothing was considered. And a notional, my lord, income was calculated 15,000, and on the basis of that, 10 multiplier, and my lord, that was given 1,54,000.
So his notional income was considered as 15,000.
15,000 only. And 10 multiplier.
So multiplier how much? As per the schedule, how much should be the multiplier?
My lord, at least 18 multiplier should be the multiplier.
No, you see, the multiplier here is 15.
My lord. May I place the judgment, my lord?
Yes.
My lord. My lord, 5 issues were framed, my lord, by the court. If your lordship kindly turn to
He was a student of which class?
class 9, my lord, and he was 5'7" tall, and my lord, he was brilliant in his academic and also, my lord, in sports. And my lord, he hailed from a Marwari family. He participated in the business that was in evidence. That was not disputed, my lord. And his there was gifts and investments were from, my lord, his earning was, last income tax payment was given 5,300 something, against, my lord, his income 46,000 something, my lord. So, my lord, considering that aspect, my lord, his income should be taken into consideration 46,000 something minus the deductions, my lord, and my lord, he should be given the, my lord, my lord, the multiplier at least 18, my lord, in view of the facts of this case, my lord. My lord, if your lordship kindly turn to.
Age was 15 years.
Age was 13 years, 13 years, 13 years.
Student of class 9.
Class 9. My lord, kindly come to page 90, my lord.
Page 90.
90, my lord, of the paper book.
Yes.
6 issues were framed by the learned tribunal. First, is the case maintainable in the present form? Second, did the victim meet with an accident on 2/9/2003 involving the offending vehicle bearing number so and so, resulting his death? Did the accident occur on account of rash and negligent driving of the driver of the offending bus? Was the vehicle in question covered by policy? Age of the victims entitled, are the claimants entitled to get compensation as paid for? To what other relief or reliefs as the claimants are entitled? Lord, the issue number 1 was decided in his favor, and issue number 2 and 6 were taken together, my lord. That is page 92. Kindly come to page 92, my lord.
Anyway, with regard to rash and negligent driving,
My lord, that was proved.
anyway, against that there is no appeal.
No appeal.
So your appeal is only with regard to quantum.
Quantum enhancement, my lord. My lord, if your lordship kindly turn to page 92, your lordship would found.
Yes.
My lord, to establish their case, the claimants examined altogether 4 witnesses, including the petitioner number 2 as PW2, and filed series of documents which are marked as Exhibit 1 to 15. The claimant petitioner number 2, Sushil Kumar Sabbu, deposed in the case to prove the fact that the claim application and also submitted that his son, aged 13 years, was a student of class 9 of Sri Daulatram Nopapani Vidyalaya. His son was only future earning member of the family, and he had income of rupees 46,850 from several investments in various schemes and paid income tax of 5,390 for the said year. PW1 accordingly claimed 50 lakhs towards loss of sufferings and loss of amenities, loss of discomfort, etc., loss of rupees 50 lakhs towards economic loss, future loss of earning capacity and loss of income, and 10 lakhs towards loss of life and their only male son, 50 lakhs towards loss of their personal injury, pain and sufferings and mental trauma and disorder, 57 lakhs towards loss of expectation of life, totaling an amount of rupees 2 crores to 27 lakhs. I admitted that they already received 50,000 on the basis of an application under section so and so. In cross-examination, PW1 stated that the deceased was their only son and his business and entire family used to depend on him, and he has got enormous prospect in future. As such, they claimed compensation as aforesaid. He further admitted that he used to pay income tax on behalf of his son along with his own income, and the asset in the name of his son is still under control. On recall, PW1 stated that apart from education, his son used to participate in the business, and capital of his business was exhausted because of poor management of their business or the accidental death of his son. He has further stated that out of 2 shops he had so and so suffered a loss. Then he has specifically stated that the accident occurred due to the involvement in rash and negligent driving of the driver of the offending bus. That is not disputed, my lord. That was corroborated by the other PWs, my lord. Then, my lord, page 96, kindly I skip over to page 96, my lord. I find that the investigating officer, after due investigation of the case, submitted charge sheet against the driver of the offending bus. Ramapasi is satisfied his guilt. Exhibit 3 is the copy of the post-mortem report, which also shows that the autopsy surgeon, after holding post-mortem over the dead body of the victim.
See, there is no dispute with regard to
My
the rash and
lord, nothing. No, all the points, my lord, except, my lord, the quantum of compensation. How the learned judge, my lord, dealt with. My lord, because he is aged about 13 years, below 15 years, so, my lord, 1,54,000 was given lump sum, and without, my lord, the following the guidelines of the Honorable Supreme Court, that the student, the only son of the, my lord, the petitioners, who, my lord, who will be the future bread earner, and who was exceptionally brilliant, my lord, except his, my lord, physique, 5'7" my lord, his obituary was also exhibited here, where the, my lord, the principal, the teachers, and, my lord, the other students have certified that he was exceptionally brilliant in all respect. So, my lord, on the death of a, my lord, because exception cannot make a rule, my lord, because, but here in this particular case, my lord, the victim who died in an accident, my lord, he should be adequately compensated, my lord, following the guidelines, my lord. My lord, Kindly come to page 97, my lord. Now, regarding the quantum of compensation, it is the specific case of the petitioner that at the time of accident, the victim was aged about 13 years and he was a student of class 9. But in spite of that, he had income of 46,850 per annum. And in paragraph 7 of the claim application shows
47,850. What was the source of income?
my lord, his relatives, his parents, everybody gifted, and he, my lord, utilized it in investment. And from the investment, my lord, he earns with 46,000 something, my lord, in the year, my lord, mentioned there, my lord, and he paid 5,350, my lord, towards the income tax. My lord, the witness, my lord, from the income tax department was also examined, my lord, and my lord proved the balance sheet, my lord.
Where? Which page?
Lord, that your lordship would found, my lord, the deposition of my lord, page 53. PW4, my lord. Your lordship got it. I have come to depose on receiving summons and the return of Sushil Kumar Sabbu and his minor son Chirag Sabbu, balance sheet, including documents relating to deposit of tax. This is the original IT return of Chirag Sabbu. That means the my lord, the victim, for the financial year 2002-3 and assessment year 2003-4. I have produced the same from our official custody. This bears the office seal of our office, IT return annexed and tax challenge submitted by Sushil Kumar Sabbu in our office. I have also brought the copy of balance sheet from our office. This is the forwarding letter marked Exhibit 2. These are the IT return and challenge marked Exhibit 13 collectively. So, my lord, that has not been, my lord, refuted.
No, the source of income was savings and investment.
Yes, my lord. Savings and investment. It cannot be denied that, my lord, that the income which was shown, it was not disputed even that the rupees 46,000 something which he, my lord, earned from investments, that is manufactured or that is, my lord, for the purpose of this, my lord, claim petition. There is no suggestions whatsoever. And, my lord, then, my lord, I shall proceed with the next part of the judgment, my lord, how the learned judge come to such a finding. ট্যাব দিয়ে রাখো না কেন?
Yes, except quantum, there is no other ground of challenge. Yes, Mr. Singh. Have you concluded?
My lord, if your lordship allow me to submit, my lord, the decisions, I think, my lord, your lordship would consider, because I cannot take, my lord, much stress on me for 3 months at least, because I have undergone a brain operation. So, my lord,
No, these are not very complicated case also,
no,
which
my lord,
requires
this is not a
stress,
complicated case at all.
which requires very much stress.
No. That's why, my lord, since it is a long pending matter, my lord, I mentioned before your lordship was kind enough
What
to.
is the decision you want to rely? Please show.
My lord, I will show, my lord. Let my learned friend submit, my lord, what he says against the case, my lord, against the.
No, the decision which you want to cite.
My lord.
Give me the.
My lord, kindly come to the finding of the judge also.
No, that is there, okay.
That no discussion. Apart from that, the escalation was considered by the learned judge. The escalation, what we have submitted before the learned judge, that is, my lord, page, my lord, 101.
Yes.
But in spite of that, the claimants are able to establish that their son faced a fateful accident on auto due to rash and negligent driving of the offending bus, which is obvious that they are entitled to some compensation from this case. In this case, it is admitted position that the victim was aged about less than 15 years and a case of 15 multiplier. And it also appears to me, except the earning from the savings and investments, the victim had no personal income, as it already admitted position that the said savings and earnings from the investment remain intact and under the control of so and so. As such, it is a case of notional income, considering the income of victim notionally 15,000 per annum, and after deduction of 1/3 of the same of his.
Yes, that is how the learned judge has arrived. What decision you want to rely? Please show that.
My lord, and so far the escalation is concerned, my lord, at the prevailing time of accident, my lord, it was. এইখানে উপরে থাকবে। This was calculated, my lord, and submitted before the court below.
একটু নামগুলো বলে দাও না।
না, এখন আমি দিইনি জানি। ঠিক আছে, এইটা দেওয়া হয়েছিল, তুমি এটা রাখতে পারো। কিন্তু যেগুলো পাথর হলো সেগুলো
Yes, give us some relevant decisions,
Well-
not that you have to give everything
No, my lord, not that.
applicable to this facts of the
Well-
case.
My lord, even in the case of a my lord minus who made an accident and because he was injured. My lord, in that case, even this is not a death case. This is reported in my lord 2014 0 Supreme SC 357. My lord, here, my lord, he was a student of class
Yes, give that. Give
class 11. Two step like. এটা আরেকটা কথা এটা আরেকটা কথা এটা আরেকটা কথা এটা এটা
Yes, any other?
My lord, in the case that is not in my hand, but I refer, my lord, Sharad Singh versus H.D. Narang, where, my lord, the court held that fairer compensation for students and young victims. The judgment recognizes that students and young victims may not be the earning, but their educational path and realistic career prospects must be factored. This prevents under compensation. My lord, and my lord, this Supreme Court judgment in Sharad Singh, the court held that is a progressive step in the field of motor accident compensation law by holding that minimum wages cannot be determined solely on the basis of educational qualification. The court has ensured that realistic employment prospects and the nature of work are central to income assessment. So, my lord, I am referring a case, my lord, with your Lord, the tribunal passed an order, my lord, here in this matter, my lord, 7,85,000, my lord, with 7% interest. And my lord,
What
there
was
in
the monthly income taken into
my
consideration?
lord, there, my lord, if your lordship kindly turn to page 3, the Honorable Supreme Court in National Insurance Company Limited and Pranay Sethi, my lord, has clarified the law under section 166 on the following aspects. Reduction of personal and living expenses to determine multiplicand, selection of multiplier depending on age of deceased on basis for applying multiplier, not the future prospects for all categories of persons and for different ages with permanent job, self-employed or fixed salary. Then, my lord, kindly turn to the next page, my lord. My lord, after 2 lines, my lord, we think that it would be counting that the amount that we have quantified should be enhanced on percentage basis in every 3 years.
So that is there.
And the enhancement, yes, my lord. Next, my lord, 59.8, my lord, on the same page, my lord. Reasonable figures on conventional heads, namely loss of estate, loss of consortium, and funeral expenses should be so and so, respectively. The aforesaid amount should be enhanced at the rate of 10% in every 3 years. Then, my lord, kindly, my lord, the next page, my lord. 21.3, filial consortium in the right of parents for compensation in the case of an accidental death of a child. An accident leading to the death of a child causes great shock and agony to the parents and family of the deceased. The greatest agony for a parent is to lose their child during their lifetime. Children are valued for love, affection, companionship, and their role in the family unit. Consortium is a special, my lord, thereafter, my lord, kindly come to my lord, last but one page, my lord, paragraph 12. Further, the learned tribunal has heard in not awarding future prospects, which should be 50% as per settled law in Pranay Sethi's case supra. Then, my lord, paragraph 13. Furthermore, the amount awarded under the conventional heads of expenses, loss of consortium is on lower side. No amount has been awarded for loss of estate. Therefore, the award requires intelligence of this court. And, my lord, ultimately, my lord, the Honorable Supreme Court enhanced the, my lord, quantum of compensation.
কি নাম দাদা?
এটা প্রণয় সেতী থেকে রেফারেন্স করলাম। My lord, I take your leave because one matter was called on in court number 1. So, my lord, let my learned friend argue. My junior is there.
You want to reply after your learned friend argues?
My
Then the matter cannot be completed today. You have to argue on the next day. Yes.
My lord, if he concludes it today, then my lord, I'll start. Otherwise, my lord, I'll give and then again he will.
No, reply. He has to reply.
I am to reply. I am to reply.
Yes, I understand, my lord.
So let him reply on the next day. You submit. Because it's a old matter, it has to be
Yes, yes.
concluded.
My lord, I'll take not more than 10-15 minutes. So that is why, my lord, I say, my lord, the day he's ready for reply, on that day I'll conclude my argument with regard to the opposition. So that on the same day it can be concluded. He has to be there, my lord. He has to listen to what I'm saying. I won't.
No,
take
no,
more
my
than 10
junior
minutes.
is there. He will
My-
take note.
my lord,
You argue, you finish it.
But then
Because
stay,
it will
stay
not-
for 10 minutes.
Because in reply, what you will submit,
My lord, then
unless you,
stay for 10 minutes. I'll finish off my argument in 10 minutes.
No, no, one matter called.
anyway, so let it be taken up tomorrow or day after
Not
tomorrow.
My lord, tomorrow.
এই কালকে
Day
দেখো
after tomorrow, my lord. Day after tomorrow.
বাবু স্যার শনিবার আছে যেহেতু
Oh, day after শনিবার.
তাহলে সোমবারে করো কালকে করো সোমবার।
Monday to monthly list.
I am keeping it tomorrow.
My lord.
Yes. ঠিক আছে একটা কি ইয়ে ম্যাটার ফিক্স আছে এমএসসিসি কেস থাকে অসুবিধা নেই তাহলে
My lord, I take your leave, my lord.
তুমি যা বলে যাও আমি
দরকার নেই,
খুব
ওটা
ছোট সময়
কালকে
নেবো, তাই
দিয়ে
জন্য
দিন 10:30 হ্যাঁ এই শেষ
কি
করতে হবে
অসুবিধা হচ্ছে ওকে অনেক
এরপরে আমি
হয়েছে কি জ্ঞান জ্ঞান করছে
Yes, record.
My lord, I take
Learned
your
advocates for the parties are present. Mr. Rai submits but could not conclude his submissions. Let this matter appear. Acha, Mr. Rai, learned advocate for the appellant, concludes his submission. Let this matter appear on 30/1/2026 at 10:30 a.m. for further hearing.
Yes,
So you submit, thereafter he will reply
My-
and it
my
will be
lord.
concluded.
extremely obliged your lordship.
My lord, I am appearing on behalf of the appellant, my lord. Mr. Pahari is appearing in this case, my lord. I have already talked with Mr. Pahari. Kindly fix a date for hearing. My paper book has been, my lord, filed. I shall inform Mr. Pahari.
Yes, record and order. Learned advocate for the appellant is present. As the appeal is ready for hearing and the paper books are filed, let this matter appear for hearing. আচ্ছা দেখুন তো কবে আছে 14, 12, 13 10:30 12/2/2026 at 10:30 a.m.
My lord. I shall inform my lord, Mr. Pahari.
My lord, in this matter, your lordship directed the matter to go for mediation
Yes.
and it has failed, my lord. So if your lordship kindly fixes any date for hearing of the application and appeal.
Hearing was almost concluded.
The application was.
আচ্ছা record and order. Learned advocate for the applicant is present. Let this, as the mediation in this matter failed, let this matter appear for further consideration on 13/2/2026.
My lord.
Let the matter appear on 13/2/2026 at 10:30 a.m.
My lord, grateful to your lordship.
Item 20. This matter was heard, but so far the respondent opposite party is concerned, some decisions were cited, but these are not on the record. So it's better the decisions which cited be brought on the record so that on the next week I shall deliver the order, pass the order. Let it be not today, okay? Come on the next day and file those decisions.
Perhaps no decision দিয়েছিলেন?
No, they filed some decisions, but they are not in the record.
I shall.
Okay, not today. File tomorrow.
Perhaps, my lord, no reference was given on that.
No, probably I know because argument was made, some decisions was also relied. But I don't see in the record. Whether you took it back or not, I don't know.
My lord, so far as I can remember, my lord, no the decisions was required.
Anyway,
But a hearing was
If no,
your senior come because he knows what decisions he relied.
Mild,
Well, I was present also, therefore I know.
So let him come, let him say.
Yes,
mild.
all right. Kalke.
Or I shall take instruction of my
Yes,
senior
not
and
today. It will appear under the same heading.
I shall take instruction from my senior.
Yes.
21, I appear for the appellate.
So written notes of arguments is filed by you.
May I file my written notes of argument?
Yes. Yes, record an order. Learned advocates for the parties are present. Let the written notes of arguments filed by the learned advocate for the appellant be kept with the record. The hearing of this matter is concluded. Let this matter appear for
final hearing, my lord. Final hearing, my lord.
okay. Let this matter appear for final hearing on.
But I believe it has been concluded. We are relying on a judgment on a
Because written notes means nothing else to submit.
Because, my lord, I am relying on a judgment similar to this matter. Two
Okay,
claim cases.
6/2/2026 at 10:30 a.m.
My lord.
At 10:30.
Yes, 6th of February.
Deeply.
'22, not this week.
My lord, 23, my lord, I am appearing on behalf of Union of India. My lord, day before yesterday, I have received the brief. I have to take instruction.
Okay, the appeal is not yet ready for hearing.
No, my lord.
Okay, not this week. Let it be not this week. Come on Monday.
Lordship.
Yes, my lord. 24, I am for the appellant. He is the first time come before your before the honorable court. Appeal is filed within time from the SR report. A stamp report says within time. So
paper books are to be filed. The trial.
No, has been direction is not there. And LCR, whether LCR has come or not, I do not know.
It has to be called for.
Yes, my lord. LCR.
Yes, record an order. Learned advocates for the.
I am submitting the affidavit of service to the other side. I have served.
Yes, Mr. Singh is appearing.
Oh, Mr. Singh. You are
Learned advocates for the parties are present. Let affidavit of service file be kept with the record.
Yes.
Let the trial court records be called for and the paper books be filed after arrival of the trial court records. The trial court records be called for at the special messenger court of the appellant. Let this matter appear after 4 weeks. Liberty to mention.
Yes, LCR. My lord, LCR should be called for.
I've called for the trial court record.
Sir, it is sorry.
Special messenger cost.
It is sorry to mention there is a standing order of the Honorable High Court that department superintendent will call for the record LCR because
anyway, sometimes it is dispensed with also. That is why I specifically directed.
Yes.
Is here at the special messenger cost.
It need not require any further order of the court.
But if it is special messenger cost, then that has to be incorporated.
Yes, my lord. Oblige, my lord.
I am appealing for the respondent claimants, your lordship. Mr. Rai is appealing for the appellant. Also, I have prepared the paper book as per direction of this honorable court. You see, this appeal is only on quantum point.
Yes, record an order. Learned advocates for the parties are present as the paper books have been filed and the appeal is ready for hearing. Let this matter appear for hearing on yes, when you will be ready next week?
Next week.
Next week, all this military, this time.
13/2/2026
13/2,
at 10:30 a.m.
10:30. Deeply obliged, Your Worship. পঁচিশ ছাব্বিশ
26 and 27.
My lord, I am for the
27,
appellant.
28.
27/28, Lordship.
My lord, I am for the appellant. My lord.
I am also for the appellant because of the common judgment against the two fresh appeal paper by the insurance company one and from side of the claimant another appeal.
So paper books are ready.
Everything
All
ready.
filed, my lord.
Lordship, is the quantum is the only issue. Mr.
Record an order.
Lordship, kindly is the issue of quantum. The Lordship, if Lordship to today Lordship time will permit, then Lordship remain in same position. Tomorrow, I believe we will do the matter and finish
There
it.
are so many matters pending.
So Lordship, let's remain in same position.
I cannot assure you. Okay. there
Very
are
well, Lordship, remaining same position.
matters also pending. So you can wait for some time.
Lordship, is the
Learned
they are
advocates
suffering, Lordship.
For the, you see, this is a 25 matter. There
No.
are other old matters also.
No, Lordship, because of it is the matter of 20. Because of their insurance company paper and appeal. They are enjoying the interim order. Kindly MEC case number 2020. It is not the 25. Kindly, Lordship.
The learned advocates for the parties are present. As the appeal is ready for hearing and the paper books filed, let this matter appear for hearing on 13/2/2026.
My lord, not. I have personal difficulties on 13th. Lordship may kindly fix it up on 14th or 15th any day.
আচ্ছা 12 তারিখে দেখুন তো 12 তারিখে 12
Lordship.
2/2026
Yes.
at 10:30 a.m.
Lordship.
Lordship.
Good. 12 তারিখ।
Twenty-nine.
29, I am appearing on behalf of the appellant insurance company, my lord.
Appearing for the respondent.
I have received the paper book. Matter can be disposed of. My lord will kindly fix up
Filing
a
the
date.
paper book, my lord.
Other formalities are complete.
So it is your appeal.
It is my appeal.
Yes, learned advocates for the parties are present. As the paper books have been filed and the matter is ready for hearing, let this matter appear for hearing on 16/2/2026 at 10:30 a.m.
16th February, my lord. Grateful, my lord.
Grateful, my lord.
Deeply obliged.
Yes, my lord, this appeal has come at my instance. My lord, your lordship, my lord, on November 13, 2025, my lord, the judgment was delivered. The appeal of insurance company and my appeal cross objection both are dismissed. Now, my lord, here,
So why are you mentioning after such a long time, after 2 months?
your lordship kindly, my lord, your lordship kindly see the last order passed by your lordship on 17 November 2025.
17?
17 November 7/11/2025.
7/11?
11.
No, this is November 13, 2025. The judgment was delivered.
Yes. Thereafter, the matter appear
When?
on 17/11/2025.
Okay, where any order is passed?
Yes.
Let me see. 4/11. 17/11 অর্ডারটা দেখি। তো ডিসপোজ ম্যাটার্স আসছে। 17/11 কি আসলো অর্ডারে?
My lord, this order reflects, my lord, that the my lord, Registrar General is directed to disburse the amount deposited by the insurance company. My lord, your lordship kindly see. Paragraph 5. The Registrar General High Court Appellate Site is requested to release the awarded sum deposited by the appellant insurance company within a period of 3 weeks from the date of communication of the order upon necessary verification and compliance all formalities. Now, my lord, what I am mentioning, my lord, why it has come today before your lordship, that the deposit made, my lord, long ago, and my lord, deposit has been directed to be invested by the learned registrar, office of the learned registrar.
So, my lord, one line, my lord, one word, the deposit with accrued interest. My lord, we approach before the office of the London Registrar General. My lord, the office says the deposit only you are entitled, no interest. Why? Because the interest, my lord, has been
When it was deposited in the fixed deposit?
My lord, your lordship, kindly see
No,
the
this is
order passed by your
2025.
lordship. It was deposited. My lord, your lordship, kindly see.
This is a 2018 matter.
Yes, my lord, your lordship, kindly see the my lord in the order sheet. My lord, first 25,000 as statutory use. First page. और जे একটু জজকে দেখিয়ে দিন না ও ডিপোজিট গুলো কবে কবে হয়েছে 13/1/2018 অর্ডার শিটটা দিন
No, I find that it is a case of 2018.
Yes, my lord, on 3rd January 2018, statutory deposit was made.
Deposit, date of deposit. ওর তো রেজিস্টার্ডেড ইয়েতে থাকবে বোধহয় রেকর্ডে ডেট অফ ডিপোজিট হয়নি
আমাকে দিন আমি বের করে দিচ্ছি তার মধ্যে নেই অর্ডার শিট গুলো অর্ডার শিট আছে এর মধ্যে ওই তো অর্ডার শিটের মধ্যে my lord, on first deposit 25,000 thereafter deposit made on my lord on 2018 1,57,473
ডেটটা বলো না
ডেটটা আছে অর্ডার ডেটটা না ডিপোজিট চালান নাম্বার রয়েছে
ডিপোজিট ডেট
আমাকে তাহলে একটু অর্ডার শিটটা দিন আমি ডিপোজিটটা দেখিয়ে দিচ্ছি
My lord, certain basics are to be clarified. My lord, your lordship will kindly ask for my lord's officer. Because my lord, in his favor I speak, my lord, he is entitled for entire deposit.
That means everything, it is to be clarified in the award, its order itself.
My lord, my lord, even if my lord's order does not specify so, my lord, in the letter and in spirit of the order is whatever money is there, he is entitled to. My lord's officers say that no, my lord is not clarifying that the interest also has to be given to him. They are not following the spirit of the order, my lord, that whatever deposit insurance company has made, since the appeal has been dismissed, claimants will take the entire money, entire deposit. Deposit always would include the interest part. They say that no, we will not give interest because my lord has not specifically mentioned the interest part. Your lordship will call for them and make them understand, my lord, because in every general order, my lord, because in every other order, my lord, this difficulty, my lord, they face. I am on behalf of the claimant, I submit so, my lord, because every time they come up before their lordship, and your lordship, my lord, has to clarify, yes, along with accrued interest, along with accrued interest.
My lord, your lordship, kindly see in the left hand side what amount my lord has been deposited.
Yes.
My lord, the spirit of the order has to be understood.
Here I think there is no difficulty because entire.
There is no difficulty, but still, my lord, they have to understand the spirit of the order, my lord.
And my lord, the deposit, my lord, has been invested by the office of the Registrar General. Now, my lord, your lordship, my lord, since my lord, the appeal was dismissed, and my lord, your lordship says that the claimants be permitted by subsequent or be permitted to withdraw the deposit amount only, not deposit with accrued interest. My lord, deposited amount has been invested by the office of the London Registrar General in the National Bank. That will accrue the interest. Mother, may I put question myself? Why my client will not get the interest thereafter investment? Mother, your lordship, kindly the subsequent order on 7/11/2025. The Registrar General of the affidavit side is requested to reveal the awarded sum deposited by the Mother, deposited amount with accrued interest. Kindly, my lord, at one line.
Yes, record an order. Learned advocates for the parties are present. The matter is put up for necessary clarification of order dated 17/11/2025. Stop. This appeal FMA 1326 of 2025, along with COT 146 of 2024, was disposed by judgment and order dated November 13, 2025, in which the said appeal and the cross objections were dismissed. Stop. By order dated 17/11/2025, pursuant to the disposal of the appeal and the cross objection, it was the Registrar General High Court, Calcutta, was requested to release the awarded sum deposited by the appellant Reliance General Insurance Company within a period of 3 weeks from the date of communication of this order, upon necessary verification and compliance of all the formalities. Stop. It is submitted by learned advocate for the claimant, respondent number 1 and 2. Respondent number 1, that the department that the accrued interest is not being released in the absence of specification in order dated 17/11/2025. Stop. Although in terms of order dated 17/11/2025, the release of the awarded sum deposited also includes the accrued interest, but it is further, but in order to remove the difficulties, it is once again clarified that the claimant respondent number 1
and 2.
Respondent number 1 and 2.
1 and 2 and 3.
1, 2 and 3. Claimants
Yes.
are permitted to withdraw the awarded sum deposited by the appellant's Reliance General Insurance Company along with accrued interest. Other contents of the order dated 17/11/2025 remain unaltered.
Obliged, Your Lordship. I'm obliged.
My lord, actually, this matter was running under the heading of Part Heart
You are appearing for?
the petitioner.
I am appearing for the
So-
opposite party number 2, my lord.
So, what, my lord, actually, I have mentioned just few days back to correct my spelling. In the last 2 orders, my spelling was wrong. That was the only my submission was.
My lord, this matter has been
And
marked as
this,
part hard.
my lord-
This matter
my
cannot
lord-
be kept waiting for a long
My
time.
lord, one
because it
more
has
point,
become
my lord, one more
infructuous.
point. My uncle has expired
Just a
and
minute, just
I
a
have to
minute,
go to
please.
my.
No.
That matter was fixed, so my lord, kindly see the order dated 12th of December 2025.
Yes, my lord, it was running under Part Heart, but it was not listed.
Let the matter
I have
appear on the
mentioned
13th of
It
December.
correct my
no,
name.
was this marked part hard?
Yes, it was under the
By
Part Heart.
which order?
Against the order, my lord, last
in
order.
which order it is marked part hard?
Yes, no, that has
Yeah,
been.
the order
that has
was,
been marked part hard. Just we are referring.
yes, this is the order dated 12/12/2025.
No. ওতে part hard বলা ছিল না। তার আগে বলা
No,
ছিল।
yes. Well, it was on my lord. I mentioned that it was on.
Order dated 1st of September
Yes.
2025.
Yes, it was Part Heart, and after that, it has come under the heading of Part Heart. My
10,
lord.
paragraph 10. Let the matter appear on the.
So today what correction is required?
My name was, in fact, wrongly spelled in
Which
last
page?
2 order. Rajat, it should be Rajat Kumar, Rajat, R-A-J-A-T, instead of R-A-J,
Within order, that would be corrected. There would not be difficult.
RAJT.
R-A-J-A-T, yes, my lord.
Yes, record an order.
My lord, may
And
I-
my lord, kindly adjourn this matter for, because my
Learned
uncle has.
advocates for the parties are present. This matter is put up for necessary rectification of order dated 13/1/2026. In order dated 13/1/2026, the name of the learned advocate for the petitioner is marked as Raja Kumar Dhar, but it should be corrected and made as Rajat Kumar Dhar, R-A-J-A, Rajat Kumar Dhar, R-A-J-A-T-K-U-M-A-R-D-H-A-R. Stop. Let necessary rectification be made with regard to the name of the learned advocate for the petitioner. Other contents of the order dated 13/1/2026 remain unaltered. Stop. As this matter was made part heard and this court is unable to take up this matter due to the pendency of several other matters, the part heard is treated to be cancelled and the matter be released from this list and be placed before the regular bench.
Milord, the part there is no difficulty, Milord. We don't have any objection.
Not, my lord, what is happening, it can be hard next
At
week.
present, you see, I am unable to fix this matter because you have
Only
because you have some urgency. Okay, that is why I have released.
Okay,
this
my
matter.
lord, can it be, my lord, my humble submission is,
The order dated
my
12th of
my lord,
December 2020.
Yes,
my lord, my
yes.
humble submission is that can it be adjourned for next week or day after?
You see,
After 2
Milord,
weeks.
let me see the last portion of the order dated 12th of December
My lord,
2025.
yes.
As the matter is sub judice before this court, the parties may seek adjournment before the learned
Yes, my
appellate
lord.
court and the which may be considered.
Yes, my lord, we have
By
adjourned.
dint of the order,
Yes.
the next date is Milord the 4th.
Whatever it is, you see, I have released this matter because it is
My
difficult
lord,
for me
kindly
to
don't.
take up this matter.
My-
So you get it mentioned and listed before the regular
My
bench.
lord, my humble submission, kindly don't release the matter, kindly keep it
It's
in the
very
next week.
difficult, you see.
Next week or after that.
There are several matters, you see. This,
We do not have any problem, my lord.
So
My
you
lord,
recommend me to kindly interfere
can
with
keep in the,
which we have
my lord can
whatever
keep
it
in
is, you
the,
get this matter heard before the regular bench.
my
Milord,
lord,
pursuant to this order, Milord, the
So
next
that
date
can be
will
modified.
stalled.
no, my
The
lord,
4th is the
my
date,
lord, my
Milord,
lord,
it is short
Okay.
time, that cannot be
my
done.
lord,
So get
my
it
lord,
heard by the regular bench. I am not holding this matter.
my
So,
lord,
Milord, this part of the order may be recalled.
That is not necessary.
no, my lord, no
Milord,
alteration.
otherwise-
My lord,
Milord,
no,
otherwise
my
you
lord,
don't
kindly
Please don't complicate things. You
Yes,
get
yes,
it
yes, my
listed
lord, yes.
before the regular
My
bench.
lord, kindly make it in next
was
week
your
or
lord's-
after
Not
week.
possible, please.
Milord, it was
In this month, in
What
February,
is the difficulty to get it before the regular bench? I don't understand.
because
It was your lordship's
it was
pleasure
my
to
heart.
keep the matter as part
Well,
heard,
I
because
thought that
substantially
the
you have
matter,
heard of
probably the matter was sent to mediation, okay?
Yes,
Yes,
yes.
So I was of the impression the matter would be settled and it will not take much time. But as the mediation has failed, it
Yes.
will take long
It
time.
become infructuous because
No,
the
no,
arbiter
not
already been
inflection. No,
submitted,
no,
Milord.
Very good,
my
very
lord,
good.
this is
And
a,
they are
this is
challenging
a,
the propriety of the
constantly,
FIR, nothing
constant, my lord,
remaining.
constant
I have
harassing.
released the matter, take all these points
My lord,
for the regular
constantly harassing. They keep on changing the IO, the reinvestigation every time. They are not satisfied.
Very well, very well.
Only
Very
three
well,
witnesses are.
very well. All these avenues are open.
May I seek for an accommodation? Single line, Milord. Single
no,
line.
What you want?
Pendency of this application will not debug.
No, my lord, no, my lord. That is wrong.
Because there is a
that
specific.
is wrong.
You see, don't repeat things. You see, get it clarified from the regular bench.
Milord, kindly appreciate my anxiety, Milord, by
But-
dint of the
but-
observation.
my
Milord,
lord,
the date of this court.
my anxiety is more than his
For
anxiety.
few days, nothing will happen.
Yes, my lord. If my lord can keep in the February, end of February,
It's
then-
not possible. It's not possible.
Oh, grateful.
Your lordship was kind enough to, my lord, take up this matter yesterday. And this is a second appeal arising out of a suit for eviction of a bhadatia under the Tenancy Acquisition Regulation Act of 2001. My lord, the paper book has been, my lord, filed. The lower court record has been, my lord, the matter, my lord, culminates from the application under Order 7, Rule 11, which has been filed by my client. The defendant is the appellant before your lordship. Initially, the trial court was pleased to, my lord, reject the plaint, dismiss the suit, holding that the suit is not maintainable.
Now the matter has to be heard out.
My lord.
Yes, you are for the appellant.
I am for the
respondent.
appellant. Defendant appellant. My lord, it's a preliminary stage of the suit. Only the plaint was filed. After the plaint was filed, the defendant came up with an application under Order 7, Rule 11 that was allowed by the trial court, holding that the suit is not maintainable. Assailing that order, my learned friend, my lord, preferred first appeal. First appeal, the finding of the trial court was set aside, against which, my lord, this appeal has been, my lord, filed before this honorable court. My lord, before I take up the, my lord, points of law as framed by the honorable division bench.
So eviction suit was filed by the respondent.
By the respondent. My lord, may I start this way, my lord? My lord, the lower court record is there, my lord. Lordship kindly comes to the
Because you
plaint.
see, these are the 2 points which are the
Three
three
points,
points which
yes.
are formulated.
My lord.
A, B, and C.
My lord.
So on this, the appeal has to be heard out.
My lord.
So the main ground of contention is maintainability of the suit.
My lord.
So let me see the trial court order.
First, my lord, country comes to the my lord, kindly sees the plaint. Then I will come to the trial court's order because plaint is important. It's the stage of Order 7, Rule 11 because there was no opportunity of filing written statement.
No,
We have
see, in Order 7, Rule 11, the court has to confine itself within
only the plaint.
four corners of the
The plaint. That is the reason, my lord.
the written statement.
My lord, there's no scope of written statement. and we have not
You are the defendant in the trial court.
My lord.
Yes.
My lord, kindly comes to the plaint first.
One thing to be noted, my lord, this is not a suit for eviction of a bharatia. This is a suit for eviction of a trespasser. My learned friend is proceeding, my lord, as if, my lord, the suit has been filed for eviction
That
of a
is why
bharatia.
you see, Order 7, Rule 11,
Yes,
the scope is the court has to confine
confined
itself
with
to
the abatement of the plaint,
plaint. The court-
treating it to be as a 2-1,
Whether the court confine itself to the abatements of the plaint.
my lord.
That means I have to see the plaint.
My
and-
lord, that is the reason.
Yes, where is the plaint?
Yes,
Ye ta dekhiye. Is there any other supplementary paperwork filed?
No, my lord.
Which page you have annexed?
My plaint is not because the two judgments are there and the orders.
Well,
my lord. If your lordship so
let
desires,
me
my lord,
see
I
the
can
trial
hand
court.
over a copy of
My lord, I have a copy of plaint, my lord.
and annexed with my application for stay. And that is the lower court record is before your lordship.
Yes.
My lord, may I just start from, my lord, page 2? It's a shorter plaint, my lord. My lord, the concise statement states this way: suit for eviction and recovery of khas possession valued and such, and also for damages. My lord, I will just go, my lord, only 3 paragraphs. My lord, may I place it? Paragraph 1.
As a whole.
The plaintiff's father, namely Gauhar Hossain, since deceased, during his lifetime was a Thika tenant in respect of a portion of land at premises number B/2/H/7, New Tangra Road, previously known as 2 New Tangra Road.
Still recess. Other matters, daily still recess.
Other matter till recess. Other matter.
New Tangra Road under Police Station Tangra, Kolkata 7,46,000, and he was the owner of the structures, sheds, rooms, etc. erected upon the said Thika land at the said premises, and his name was recorded in the assessment register of the Kolkata Municipal Corporation as the owner of the structures standing upon the Thika land at the said premises. That the said Thika tenant, Gauhar, alias Gauhar Hossain, died on 7th July 1967, and after his demise, his son, being the plaintiff, Sheikh Johar Hossain, was accepted and or recognized as a Thika tenant by the then Jamindars, landowners, in respect of the said land at premises number 2, New Tangra Road, subsequently known as B/2/H/7, New Tangra Road, Kolkata 46. And accordingly, the plaintiff used to pay ground rent to the then Jamindar landlords in respect of the said Thika land at the said premises against rent receipts. After promulgation of the Calcutta Thika Tenancy Acquisition and Regulation Act 1981, the said land was vested to the government of West Bengal, and the plaintiff became a direct Thika tenant in respect of the land at the said premises under the government of West Bengal, and he paid ground rent to the Thika controller in respect of the said Thika land at the said premises. That the defendant's father, Sufi Muhammad Shadiq, was a monthly premises tenant under the plaintiff in respect of 14 rooms at the said premises number 2, New Tangra Road, subsequently known as B/2/H/7, New Tangra Road, Kolkata 46, and he used to pay his monthly rent to the plaintiff against rent receipts, and there had been a relationship of landlord and tenant between the plaintiff and the defendant's father, Sufi Muhammad Sadiq, in respect of said 14 rooms at the said premises. That the defendants, being two sons of the said tenant, Sufi Muhammad Said, used to look after the said tenancy on behalf of the father, who used to stay at his native village at Bihar. The defendants, on behalf of their father tenant, used to pay monthly rent to the plaintiff in respect of the said tenancy to the plaintiff against proper rent receipts, and sometimes the defendants acknowledge the rent receipts by putting their signature on the back leaf of the counter part of the rent receipts. The said tenancy of the defendant's father in respect of 14 rooms at the said premises were converted into 2 sheds by removing all the partition walls of the room, sometimes in the year 2010, with verbal consent of the plaintiff for convenience of running the business therein. Though the rent receipts were granted by the plaintiff in the name of the defendant's father in the previous manner in respect of 14 rooms at the said premises, even the defendants or their father never asked the plaintiff to change the description of the tenancy in the rent receipts. The rent of the said tenanted property of the defendant's father was lastly paid by the defendant on behalf of their father for the month of March 2020 at the rate of rupees 10,000. The said tenanted property of the defendant's father at the said premises under the plaintiff is the subject matter of the present suit, and the same has been more fully described in the schedule hereunder written and hereinafter referred to as the suit property. That sometimes in the month of April 2020, the plaintiff came to learn from reliable source with his great surprise that the defendant's father, Sufi Muhammad Sadiq, being the original tenant of the suit property, passed away more than 10 years ago, but by way of deliberate suppression of the death, news of their father, the defendants continued to pay the monthly rent to the plaintiff at the rate of rupees 10,000 per month up to the month of March 2020 in the name of their father, and accepted the rent receipts from the plaintiff in the name of their deceased father without disclosing the fact of the death of their father to the plaintiff. That after coming to know the said fact about the death of defendant's father in the month of April 2020, the plaintiff requested defendants to confirm the death news of their father, and the defendants verbally admitted before the plaintiff about the death of their father, who died almost 10 years ago, but they denied to hand over any copy of the death certificate of their father to the plaintiff. The plaintiff accordingly was compelled to stop to accept the monthly rents from the defendants and stopped issuance of rent receipts in the name of the deceased tenant, Sufi Muhammad Sadiq, anymore since the month of April 2020, and verbally requested the defendants on many occasions to quit and vacate the suit property, as because the defendants have already lost their right to remain in occupation in the suit property according to the provisions of law, but the defendants turned deaf ears to the plaintiff's said request. That the plaintiff submits that according to the provisions of Section 2G of the West Bengal Premises Tenancy Act, the defendants, being the legal representatives of the said deceased tenant, Sufi Muhammad Sadiq, were entitled to occupy the said tenancy of their deceased father for a maximum period of 5 years from the date of death of their father. The period of 5 years from the date of death of the defendant's father, who was the original tenant, have already been expired long ago, and the defendant's occupation in the suit property are completely illegal and unauthorized as that of a trespassers in the eye of law. The plaintiff further submits that there is no creation of new tenancy in favor of the defendants at any point of time, and they do not have any right to remain in occupation of the suit property for any further period, and they are liable to be evicted from the suit property under the provisions law. These are the main contention. Thereafter, notices were there, notices to quit, etc. etc. My lord, may I come to, my lord, paragraph 1. Paragraph 1, my lord, next paragraph I just skip because those are, my lord, usual paragraphs that notices were issued. We did not comply with the notices and thus there were such and such, etc., etc. It kindly comes to paragraph 1. Paragraph 1 of the plaint.
Yes.
That the plaintiff's father, namely Gohar Hussain, since deceased, during his lifetime was a thika tenant in respect of the portion of land at premises number such and such, and he was the owner of structures, said room, etc., erected upon the said thika land. The plaintiff admits that this is a thika land and he is a thika tenant. And he also says that this particular property was recorded in the assessment register of the Kolkata Municipal Corporation as he is the owner of the structures. Therefore, it is an admitted position that the land, the suit property, is a thika land and he himself is a thika tenant. And thereafter also in paragraph 2, he says the plaintiff admits that he used to, the original Jamindar landlords used to recognize him as the thika tenant and he used to pay ground rent to the then Jamindars. And after promulgation of Calcutta Thika Tenancy Act of 1981, when all the properties vested with the state, he became a direct thika tenant in respect of the said premises under the government of West Bengal. These are all admitted. Paragraph 3, very important, he says that the defendant's father, Sufi Muhammad Sadiq, was a monthly premises tenant under the plaintiff in respect of 14 rooms. That means, my respectful submission that the defendant is a tenant under the thika tenant, which is Bharatia. This is the admitted case. It is admitted that the property is a thika property and he is a thika tenant duly recognized prior to 1981 by the Jamindars, thereafter by the state authorities. His name is recorded and the description of the property in the assessment register of the Kolkata Municipal Corporation says that this is a thika property. And he admits that my father is, my lord, a tenant under the thika tenant, which is Bharatia. This suit was filed with the contention that the original Bharatia died long time ago. After his death, we continued to occupy the premises, go on paying rents. At one point of time, he realized that the original Bharatia died and still we continued. A notice under section 2G was to be, my lord, served upon me. And my lord, as we have not complied with, my lord, and
you are paying rent. Your client's predecessor was paying rent to
the thika tenant,
to the plaintiff.
To the plaintiff.
That rent he was, and definitely receipts were issued.
Receipts were issued. That is the plaint case, my lord. That is the plaint case.
So that was being issued.
That was being issued. And he admits that at some point of time it was not issued. And even it is his case, plaintiff's case, that after we also, the defendant also continued to pay some amount of rents, even after the death of my lord. My lord, death, no proof whether he died. He says that the defendant have acknowledged, yes, he is died, etc., etc.
No, question is, that means your father was the
thika tenant.
No.
Bharatia.
Plaintiff's father.
Plaintiff's father was a thika
Plaintiff's
tenant.
father inducted you.
Plaintiff's father inducted my father.
Yes. Thereafter, rent was received from your father.
My father. Even
after the death of your father, was any rent received?
Yes, that is the plaint case.
Okay.
That is the plaint case, your lordship.
Okay.
Kindly says.
That rent was received from you also.
No, mine.
That rent was received from him. The receipt was issued in the name of the father of the present defendant. Not in the no new tenancy was created.
After the death, how many months you have received rent?
My lord, we do not know, my lord. They did not inform us. But all along, my lord,
Anyway, that means prior to the institution of the suit, you stopped receiving rent.
Yes. Now, what is the status at present?
And after this suit was filed, I have placed the plaint, my lord, on receiving the, and your lordship kindly also, my lord, take trouble to come to page 8, the schedule of the property. The schedule of the property, as in the plain case, he says all that 14 rooms now converted to 2 sheds, everything admitted. Even 14 rooms with consent, we have converted into 2 sheds, brick built world standing upon a Thika tenanted land. Premises number such and such, etc., and list of documents, ground rent receipts, tier form 7, certified copy of inspection books, NOC issued by KMC, etc., Death certificate of Gohar Hossain, the original Thika tenant, his death certificate, property tax bill, all these documents and the schedule says that this property is a Thika property.
So up to date rent receipt paid to the Thika controller. Up to date rent.
They have paid. They said that they have paid.
We are paying khazna to the Thika controller.
No. Chalan showing payment of ground rent. Anyway.
Yes, ground rent. That is to be paid by the Thika tenant.
Khazna.
Khazna to the controller.
But admittedly, all this schedule and the plain case and the documents relied on the plaint is that there is no dispute, no confusion that this particular suit property is a Thika land, is a Thika property. And the plaintiff, originally the plaintiff's father was a Thika tenant, and after the death of the plaintiff's father, the plaintiff is a Thika tenant. This is, my lord, admitted position in the plaint. But after this suit was filed, my lord, we came up with an application under Order 7, Rule 11, saying, my lord, that this particular suit is not maintainable before this particular forum because of the availability of alternative forum.
Alternative forum means if a suit is barred under law, no question of alternative forum.
My lord, suit,
If suit is barred under law, Order 7, Rule 11 is inevitable.
This particular forum, I tell you,
the plaint, if it appears that the suit is barred under law, definitely
this particular
Order 7, Rule 11 will apply.
court, this particular civil court have no jurisdiction. That is our case in our Order 7, Rule 11. Because the law mandates that. Now, my lord, may I place the, my lord, judgment passed by the, my lord, trial.
Let us see the judgment. This is the plaint. Where is your Order 7, Rule 11 application?
My lord, Order 7, Rule 11 application, my lord. I'm just handing over. It's with the lower court record also. I'm just handing over. Just give me a moment, sir. To lower court record.
May I hand over this copy?
His appeal is to be heard out on the points formulated.
My lord.
But there is some distinction I'm telling, my lord.
May I place it?
Yes, let me
This
see.
is not a suit for eviction of a bharatia. Distinction is, my lord.
See, what is that means? Additional grounds can be formulated if both the parties, after hearing both the parties,
My lord.
if it
Because this is
seems-
a suit for the eviction of a trespasser. That is a distinction.
so trespasser under 2G.
Under 2G. Now their status is under 2G because they do not have any right to reside in the property after expiry of 5 years.
Question is, did you admit the original tenant, his father, as a tenant under the West Bengal Premises Tenancy Act? Did you admit him? If you did not admit him as a tenant under the West Bengal Premises Tenancy Act, then this act does not come into force.
My lord.
If the original,
Yes, I admit. I admitted that section 8.
you admitted him, you being a Thika tenant,
Yes. He is a
the relationship between his father and your father under West Bengal Premises Tenancy Act.
Yes. Section 8 says.
So let us see that.
Section 8 of the act says, my lord.
I will place, my lord. I'm going to order.
So let me see your Order 7, Rule 11 application.
My lord, paragraph 1 says that this is a suit for eviction, recovery of cause possession, praying, my lord. Paragraph 6, my lord. that the plaintiff has specifically stated in his statements in the plaint that the suit premises is a Thika tenanted premises. As such, the plaintiff has no right to file the instant suit against the defendant number 1 and 2, which is barred by law under section 21 and section 8(3) of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001 as amended, and as such this learned court has no jurisdiction to try and entertain the suit, which should be nipped in the bud and rejected, as the cognizance of which is impliedly and expressly barred by the Thika Act as aforesaid. The defendant number 1 and 2 craves leave to file relevant documents at the time of hearing. Under the provisions of law, this suit, which is perverse, harassing, and malafide, is not maintainable in the eye of law and liable to be rejected. Otherwise, the defendant number 1 and 2 shall suffer loss and injury. My paragraph 6 is the substance of my application. It says that
let us see the judgment of the trial.
My lord.
So far the written objection is concerned of that application.
Give the-
তখন দিয়েছিলেন তো।
No, what is your contention? The instant suit is not governed under West Bengal Premises Tenancy Act, but the same is under general law and provisions of 8(3) and 8(21) of West Bengal. So, Thika Tenancy Act. So, is it your contention?
My contention is that, my lord, this is not a suit.
Oh, that means his contention that the suit is not governed under WBPT Act,
Yes.
but under this
General
special
law,
law.
of a trespasser.
That contention cannot be sustained.
No, my lord, I just cut. That is not our, the law says, my lord, we are not on that. I will place, my lord, as my lord, may I place the trial court judgment, my lord? Law is very clear that in case of an eviction of a bharatiye under the Thika tenant is to be governed by West Bengal Premises Tenancy Act, which is section 8(1). There is no doubt about it. But my case is that whether this particular civil court have jurisdiction, your lordship kindly appreciate.
Whether the suit is barred by law or not, that is the question.
My lord.
Order 7, Rule 11.
My lord. This particular forum, whether that particular forum has jurisdiction.
That means whether suit lies before the civil court or not.
My lord, that is the whole contentions, my lord. My lord, your lordship first, my lord.
Yes, now let me see the judgment.
My lord, before that, my lord, kindly just have section 21.
So let me see the judgment first.
My lord, judgment, my lord, may I place it? The order number 7 dated 21st August 2023. Your lordship got it? Page A1 of the paper book. Page 1 of the paper book. Your lordship got it?
Page 1 and 2.
My lord, it starts from page 1.
Yes.
My lord. My lord, I'm skipping the first 2 lines.
Let me see.
My lord. May I place it, my lord?
Yes.
The petition dated 22nd February 2023 under Order 7 Rule 11 of CPC is taken up for hearing. Learned advocate for the defendant submits that the plaintiff has filed this suit for eviction and recovery of possession as against the defendants with respect to the suit property. Learned advocate for the defendants has stated that the plaintiff has specifically stated in the plaint that the suit premises is a Thika tenanted premises and civil court has no jurisdiction to try this suit as per the provisions of section 21 and 8(3) of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001. So the defendants have prayed for rejection of the plaint. Learned advocate for the plaintiff submits that the instant suit has been filed for eviction of the defendants from the suit property who are trespassers in the eye of law. Moreover, the instant suit is not governed under the provisions of West Bengal Premises Tenancy Act 1997. As such, he has prayed for rejection of the petition under Order 7 Rule 11 of CPC. Learned advocate for the plaintiff relied upon decision passed by Muhammad Jamil Akhtar versus Abdul Majid, reported in 2011 Volume 1 Calcutta Law Journal, Calcutta. Heard, considered. Peruse the petition and materials on record. On perusal, it is seen that the plaintiff has stated in his plaint that the plaintiff's father, namely Gauhar alias Gauhar Hossain, during his lifetime was a Thika tenant in respect of the suit premises, and after his demise on 7th July 1967, his son, being herein the plaintiff, namely Sheikh Jahar Hossain, was recognized as a Thika tenant. Thereafter, with the promulgation of the Calcutta Thika Tenancy Act 1981, the said land was vested to the government of West Bengal, and the plaintiff became a Thika tenant, direct Thika tenant, and used to pay rent to the Thika controller. The father of the defendants, namely Sufi Muhammad Sadiq, was a monthly tenant under the plaintiff with respect of the suit premises, and he used to pay his monthly rent to the plaintiff against rent receipt. It is true that while considering an application under Order 7 Rule 11 of the CPC, the court will concern itself only with statements made in the plaint. However, in paragraph 1 of the plaintiff has stated that his father was a Thika tenant in respect of the suit premises, and the father of the defendants was a monthly tenant under the plaintiff with respect of the suit premises, and he used to pay his monthly rent to the plaintiff against receipts. The suit was filed on 24/11/2022 when the West Bengal Thika Tenancy Acquisition and Regulation Act 2001 was in force. At this juncture, the relevant provisions of Section 5(3) of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001 is set out. If any question arises as to whether a person is a Thika tenant or not, or whether the land in question is a Thika land or not, the controller, either on his own motion or upon receiving any information, may, after giving the persons interested an opportunity of being heard, and after examining all such documents and particulars as may be considered necessary, inquire upon or decide such question. The provisions of Section 21 of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001, which is also relevant herein, provides as follows. No civil court shall have jurisdiction to decide or to deal with any question or to determine any matter which, by or under this act, is required to be or has been decided or dealt with, or which is to be or has been determined by the controller or the appellate or other authority specified in the provisions of this act, and no order or judgment passed or proceedings including execution proceedings commenced under the provisions of this act shall be called in question in any civil court. The decision relied upon by the plaintiff does not squarely apply to the facts of the instant suit, as the said decision is in respect of a suit for eviction between a licensee and licensor, but the instant suit pertains to a suit for eviction by a Thika tenant against a Bharatia with respect to a Thika land. Now, to decide whether the plaintiff has right over the suit property, his Thika tenancy right in respect of the suit property needs to be discussed and decided. So, on the conjoint reading of above two provisions, it is found that this court has no jurisdiction to decide this suit, as it is barred by the provisions of West Bengal Thika Tenancy Acquisition and Regulation Act 2001, and as such, the plaintiff rejected to be provided under Order 7, Rule 11D of the Civil Procedure Code. Hence, the petition dated 22nd February 2023 is allowed on contest without cost. Accordingly, the plaint stands rejected and instant suit stands disposed of, my lord.
Okay, let me see the Section 21 and 8(3).
My lord. First, my lord, let me, my lord, place Section 21.
Yes.
Let section 21. No civil court shall have jurisdiction to decide or to deal with any question or to determine any matter which by or under this act is required to be or has been decided or dealt with, or which is to be or has been determined by the controller or the appellate or other authority specified in the provisions of this act, and no order or judgment passed or proceeding, including execution proceeding, commenced under the provisions of this act shall be called in question in any civil court. My lord, conjointly, my lord, may I, my lord, place 8(3). Lord, 8(3) conjointly, my lord, reading together, my lord.
8(3).
8(3). My lord, from 8(2) I start. 8(2). If any question arises as to whether a person is a bharatiya under a particular thika tenant, the controller either on his own motion or upon receiving any information may, after giving the persons interested an opportunity of being heard and after examining all such documents and particulars as may be considered necessary, inquire upon and decide such question. 3. Any dispute regarding payment of rent by the thika tenant to the state government or by a bharatiya to the thika tenant, or any case of eviction of bharatiya shall be disposed of by the controller in such manner as may be prescribed. But this case, what my learned friend have instituted against us, says that my father was a bharatiya and he says the suit is for eviction of a bharatiya. Now, later on he says that I am a trespasser. Well, that is, my lord, subject of trial. Whether my father died, whether there was no admission that my father died, he says, I have admitted orally my father died. My lord, 8(2), if, again, my lord, for the sake of repeating, my lord, for my satisfaction, if any question arises as to whether a person is a bharatiya under a particular thika tenant, this is the admitted case that my father was a bharatiya. But I will try to impress that now.
Means this issue, this
My lord.
defense
My lord.
of a bharatiya,
My lord.
whether that can be decided by this, whether this issue, that whether a particular person, defendant is a bharatiya or not,
My lord.
that has to be decided by the controller.
By the controller. My lord, I am grateful, my lord. By the controller. The section explicitly, my lord, says so. The controller, either on his own motion, my lord, ample power, the controller can suo moto start investigation, and your lordship knows, my lord, in many cases, your lordship have come across the controller suo moto start a proceeding that whether a particular property is a thika property, whether a particular person is a thika tenant, whether there is bharatiya, whether licensee, those are there, my lord. Ample power given to the controller. On his, whether on his own motion or upon receiving any information, may, after giving the persons interested an opportunity. He says that my father was a bharatiya. Whether I am a bharatiya, that ought to be, my lord, determined. A forum exists, and your lordship knows, a forum exists and there is a specific bar of civil code under section 21. And as framed by the Honorable Division Bench at the time of framing of issues, this particular, my lord, points of law, my lord, was framed, which is B and C.
Yes.
My lord, my lord, I also
Is there
refer to
any ground provided, ground under what provisions the Bharatiya can be evicted? Or the West Bengal Premises Tenancy Act?
yes, that is there
applies?
8.1. I will place, my lord. I will place 8.1 is there. My lord, kindly comes to section 5.1 first, my lord. Section 5. Section 5, my lord. Incidents of tenancies in respect of lands vested in the state. My lord, may I place section 5.3? If any question arises as to whether a person is a Thika tenant or not.
5.1.
Section 5.1, my lord, incidents of tenancy. 5.3, my lord.
Just a minute.
5.2 is that every Thika tenant holding directly under state.
Yes, 5.1.
5.1, my lord. 5.2 kindly sees, my lord, every Thika tenant holding directly under the state under subsection 1 shall be liable to pay state government in prescribed manner such revenue. 5.3, if any question arises as to whether a person is a Thika tenant or not, or whether the land in question is Thika land or not, the controller either on his own motion or upon receiving any information may, after giving the persons interested an opportunity of being heard and after examining all such documents and particulars as may be considered and necessary, inquire and decide such question. 5.3 says controller will decide the issue of Thika tenant.
What is the definition of Bharatiya?
My lord, Bharatiya, my lord, I'm just placing it. My lord, it is in section
2.
2, my lord. I'm just 2.1. I'm just Miss Bharatiya. My lord, section 2.1a. Lordship got it. Bharatiya means any person by whom or on whose account rent is payable for any structure, including pakka structure, if any, or part thereof, owned by a Thika tenant, but excludes any person paying rent to the Bharatiya, and any person, a person who is paying rent to the Bharatiya will not be Bharatiya. A person who is paying rent in respect of structures, including pakka structures, owned by a Thika tenant. And here the plain case is that the plaintiff is a Thika tenant and he was receiving rent from my father and subsequently from me as a Bharatiya. But section 5.3 says issue of Thika tenancy to be decided by controller. Section 8.3 says issue of a Bharatiya to be decided by the controller.
The issue whether a person is Thika tenant or not to be decided by Thika controller.
Controller.
As well as who is a whether is a Bharatiya or not.
That is also
the Thika controller.
Thika controller. I have placed the, my lord, judgment passed by the trial court. May I, my lord, place the judgment passed by the lower appellate court, my lord?
Yes, judgment of the trial court is considered. Let us come to the judgment of the
Appellate court,
yes.
my lord. Appellate court below, my lord.
Yes.
The appellate court, my lord, proceeded on the basis of two judgments, my lord, which I will try to, my lord, distinguish, and there are other judgments also which, my lord, the appellate court below have not considered, my lord. It starts at page 3. First few lines I'm skipping, my lord. The plaintiff filed the suit for eviction and recovery of khas possession valued at rupees 500 and also for damages at the rate of rupees 100. The subject matter of the suit is a Thika tenanted land at premises number B/2/H7, New Tangara Road, Kolkata 46. The plaintiff stated to be the recognized Thika tenant in respect of the suit property and that he is paying ground rent to the Thika controller. The defendant's father, Sufi Muhammad Sadiq, was a monthly premises tenant in the suit property. under the plaintiff appellant. A relationship of landlord and tenant existed between them. The defendants used to look after the tenancy on behalf of Sufi Muhammad Sadiq, who used to stay at his native village at Bihar. The defendants were paying rent on behalf of their father. That about April 2020, the plaintiff came to learn that defendant's father, Sufi Muhammad Sadiq, passed away more than 10 years ago, but the defendant respondents had deliberately suppressed the news and continued to pay the monthly rent in the name of their father. Subsequently, the defendants confirmed the death news of their father but refused to hand over a copy of the death certificate of their father. Further case of the plaintiff is that, accordance with Section 2G of the West Bengal Premises Tenancy Act 1997, the defendant as representative of the deceased, Sufi Muhammad Sadiq, were entitled to occupy the tenancy of their deceased father for a maximum period of 5 years from his death, and that the said term of 5 years having expired long ago, the occupation of the defendants in the suit property are completely illegal and unauthorized, like a trespasser. It was asserted that no new tenancy was created in favor of the defendants at any point of time for which they are liable to be evicted from the property. Notice to quit was served upon the defendants, but they did not comply. On the pleadings, plaintiffs have prayed for decree of eviction and recovery of first possession, decree of damages, cost and other equitable relief. The respondent defendants appeared in the suit and challenged the very maintainability of the suit by an application under Order 7 Rule 11 read with Section 151 of Civil Procedure Code. The appellant plaintiff filed written objection against the said application, and after a contested hearing, learned trial court held that this court has no jurisdiction to decide this suit as it is barred by the provisions of West Bengal Thika Tenancy Acquisition and Regulation Act 2001, and further proceeded to reject the plaint in terms of Order 7 Rule 11D of the CPC. Aggrieved by the order rejecting the plaint and the decree of dismissal thereof passed by the learned trial court, the plaintiff had filed the instant appeal. Learned advocate for the appellant plaintiff submitted that learned trial court proceeded on erroneous premises of law, that law do not permit traversing beyond the plaint while deciding an application under Order 7 Rule 11 of CPC. It was further pointed out that learned trial court failed to appreciate that the Thika tenant can maintain a regular suit for eviction of a trespasser, and the same is well recognized by series of decisions by the Honorable Court. It was further submitted that present appeal should be allowed and the matter be sent back to the learned trial court for proceeding. Certain judgments were relied, which I will place before your lordship. From the side of the respondent defendants, the court was taken through the provisions of Section 3, 8 and 21 of West Bengal Thika Tenancy Acquisition and Regulation Act 2001. It was submitted that learned trial court had rightly observed that it is necessary to discuss and decide the Thika tenancy right of the plaintiff of the suit property, and that civil court has no power to take such decision. Lastly, it was submitted that present appeal should be rejected. Having heard the submission made by the learned advocate for the appellant and the respondents, and on perusal of the materials of trial court record, the following question is formulated for purpose of rendering decision in this appeal. Whether the learned trial judge was justifying in appreciating the evidence on record, both oral and documentary, to arrive at a just and proper decision. Perusal of trial court records reveal that respondent defendant did not file any written statement of their defense. They have come up with an application under Order 7, Rule 11 of CPC, read with Section 151. Honorable Apex Court in series of decision have laid down that while deciding an application under Order 7 Rule 11D of the CPC, the court is to examine the averments in the plaint. The plaint required to be read as a whole. The defense available to the defendants on the plea taken by them in the written statement or any application filed by them cannot be the basis to decide the application under Order 7 Rule 11D CPC. These settled provisions has been reiterated in cases certain judgments were referred, my lord. In the instant case, the learned trial court at page 1 of the impugned order had rightly held that the court will concern itself only with the statement made in the plaint. It is also true that the plaintiff appellant had admitted in clear terms that the suit property is a Thika tenanted property. Thereafter, learned trial court proceeded to quote the provisions of section 5.3, section 21 of West Bengal Thika tenancy acquisition and observe that to decide whether the plaintiff has right over the suit property, his Thika tenancy right in respect of suit property needs to be discussed and decided. It appears to this court that from bare reading of the plaint, it cannot be concluded by the court that it has to decide the Thika tenancy right of the plaintiff. Such observation stems from assuming that a dispute regarding Thika rights will be raised by the defendants. Such observation should not have originated from reading the plaint alone. In case of Muhammad Jamil Akhtar versus Abdul Majid, 2011, Honorable Court had observed that Section 8.3 and Section 21 do not create any bar to the jurisdiction of civil court to entertain a suit for eviction between the licensee and licensor. In the said decision, determination of Thika tenancy right of the plaintiff was not considered relevant even though it was a Thika property. Again, Honorable High Court in the case of Ashit Chatterjee versus Kanailal Das has observed that it is elementary that in order to ascertain whether the civil court has jurisdiction to try and determine the suit, initially the pleadings and the trial evidence are to be looked into by the trial court. Merely raising an issue as to create a bar to proceed before a civil court would not suffice, as the court has to come to a finding that there are enough materials to justify that the issue raised cannot be decided by civil court and it has to be decided by the controller alone. Prima facie, learned trial court has acted contrary to the settled provisions of law as discussed above, for which the impugned order is not sustainable in the eye of law. Accordingly, instant appeal same is allowed on contest without cost. Order number such and such passed by the trial court is set aside. The petition dated 22nd under Order 7 Rule 11 filed by the defendant is rejected and he referred the matter to the trial court for further consideration, my lord. My lord, in my humble submission, my lord, the appellate court below, my lord, have gone into the, my lord, provisions of Order 7, my lord. Order 7, Rule 11, my lord, this is not a case that we have filed any written statement. We preferred an application, a simpliciter application, saying that this court this particular suit is not maintainable in view of certain provisions of law. My lord, no facts, no defense, only points of law. Your lordship, I'm grateful to my learned friend, have handed over the application, my lord, copy of the application. Only point of law raised by my client, the defendant appellant.
So what are
your
the
lordship.
decisions? These decisions.
Decisions, I have decisions, my lord. I will place, my lord. But in the decision of Jamil Akhtar, the suit was simpliciter, a suit filed that he was a licensee. I have those decisions, my lord. May I must just place on the facts. And my application says a simpliciter one paragraph application.
Now the facts are clear because there is no written statement.
No written
Can
statement.
Order 711 application. Now let us come to the decisions.
My lord. My lord, firstly, my lord, I will place, my lord, Chatterjee. এটা একটু দিয়ে দেবেন না unreported কেন Ashit Chatterjee 2023 ভলিউম 1 ICC 156 আপনারাই রেফার করেছেন নিচের কোর্টে My lord, the second paragraph and the, my lord, ultimate last paragraph, I will
Because on the basis of this decision, you see, 2016 3 CHN, the trial court directed, you see, trial court decided that whether the defendant is a landlord tenant or the defendant is a trespasser. On the basis of this decision, the trial court rejected the appeal. That is 2016 3 CHN. Okay. So this decision is to be considered. 2016 3 CHN, as well as the decisions which were relied before the appellate court. 2023 1 ICC.
So 20, yes, my lord, this is 2020.
So let us consider this also, 2016 3 CHN, whether it applies to your case or not. Yes, 2000, this is 2000.
My lord, this is Ashit Chatterjee versus, this is 2023, volume 1, ICC 156.
There is another 2011 1 CLJ.
1 CLJ, my lord, that also I will place, my lord. I have those decisions.
Yes.
My lord, Jamil Akhtar, my lord.
How far it is applicable?
My lord, I say, my lord, these are not applicable. My lord, may I place, my lord, Ashit Chatterjee versus Kanailal Das?
Yes.
These honorable court, my lord, have the honorable division bench of this honorable court, my lord, have held that this was a case of, in case of second appeal, the plaintiff filed a suit for eviction of a defendant on the ground that the defendant is a trespasser and he is likely to be evicted. The defendant in his written statement alleged that the property is a Thika tenanted property and the plaintiff is a Thika tenant. It is further alleged that the defendant is a Bhadatia under the plaintiff. On the basis of pleadings and documents, learned trial judge framed 11 issues. One of the issues framed by the trial court relates to the status of the defendant in relation to the said property. The trial court held that in view of the fact that the property is a Thika property and the plaintiff is a Thika tenant, the dispute raised by the defendant in the written statement is required to be decided by the Thika controller in accordance with section 8.2 of the West Bengal Thika tenancy. The learned trial judge relied on the decision of this court in the matter of Krishna Shah and others. Nitai Panda reported in 2016-3. It was held that the suit filed for eviction of the defendant tenant from the suit property, which is a Thika property, that is required to be decided by the controller. The learned court did not go into other issues at all. The learned court did not decide whether the relationship between plaintiff and defendant is landlord and tenant of the trespasser. The learned first appellate court, on the basis of evidence on record by a detailed judgment, found that the defendant to be a trespasser. My lord, here I pause, my lord. A finding was there that the defendant was a trespasser, and accordingly arrived at a finding that the provisions of section 8.2 of the West Bengal Thika tenancy acquisition has no matter of application. The learned first appellate court has taken into consideration that the defendant has failed to produce any rent receipt to show that there is a relationship between the landlord and tenant. My lord, this is distinguishable, my lord, in the fact that this particular case of Ashit Chatterjee, this culminates into a full-fledged trial. After full-fledged trial, the suit was, my lord, dismissed. Appellate court held, no, the trial court have committed because there was a finding that he is a trespasser. And as he is a trespasser, no question of deciding the issue, who is a Bhadatia, whether he is a Bhadatia. This particular case, my lord, relates, my lord, after a full-fledged trial, a full-fledged appellate court finding, my lord, the matter was, my lord, preferred, a second appeal was preferred, and second appeal was dismissed. Because there is a finding that the defendant who against whom a decree was passed, he was a trespasser. But in our case, in the case which is before your lordship, my lord, that stage has not come. We straightway came before the court that, you see, under these provisions, this court have no jurisdiction. This particular suit, my lord, have to be filed before the controller, because controller is an existing forum having all the powers for eviction of a tenancy, bharati and tenancy. And my lord, again, my lord, I'm just skipping 2-3 ones. Next, my lord, just skip the next page, my lord. While we the second paragraph, while we accept the submissions of the learned counsel for the appellant that the dispute between Thika tenant and Bharatiya has to be adjudicated under section 8(2) of the said act, but having recurred to the admission of the defendant that he has no document or rent receipt to show that he is a Bharatiya under the Thika tenant, we are unable to accept that the suit is barred under section 8(2) of the West Bengal Thika Tenancy Act, and section 21 is not applicable. In this regard, we refer to the judgment of this court in Muhammad Jamil Akhtar and Abdul Majid, reported in 2011, volume 1 CLJ, where it has been held that the suit for eviction of licensee can be heard by civil court. Like this finding that the defendant have failed to produce any document, he is a rank trespasser. In my case, in our case, before your lordship, he admits that my father was a Bharatiya, and after that I continued to occupy the premises and used to give rents on behalf of my father, and now he says that because of my father's death I cannot occupy after 5 years, my lord. This particular issue can be, my lord, taken up before the controller, because I will place section 8(1). Section 8(1) says eviction of a Bharatiya will be governed by West Bengal Premises Tenancy Act. But my case before your lordship is that whether this particular forum, whether the civil court is competent, have authority to decide the issue of eviction of a Bharatiya. The law says negative. Your lordship kindly comes to section 8(1), which probably my learned friend will harp on saying, my lord. Section 8(1), your lordship sees, my lord, because that is also, my lord, the first points of law framed by the Honorable Division Bench. There is no ambiguity, my lord. The monthly and other periodical tenancies of the Bharatiyas in respect of the structures occupied by them on payment of rents to the Thika tenants shall, with effect from the date of coming into force of this act, be governed by the provisions of the West Bengal Premises Tenancy Act 1997. West Bengal Act, in matters relating to payment of rents by the Bharatiyas and their eviction by the Thika tenants, the owners of the structure shall be deemed to be landlords and the Bharatiyas shall be deemed to be tenants under the said act. My learned friend's contention that yes, eviction suit is maintainable, that would be governed by West Bengal Premises.
Landlords means the Thika tenant.
Thika tenants. Malat, there is no dispute. Yes, this particular law would be applicable, but my contention, respectful contention, civil court have no jurisdiction. A full-fledged tribunal controller have to decide.
See, for eviction of a Bharatiya, which is the proper forum under the
Controller.
No, where?
Yeah, I tell you, 8(3), my lord.
8(3).
8(3).
Any dispute regarding?
My lord, again, my lord, I'm just
placing it. Any case of eviction?
Any case of eviction, my lord, I'm grateful, my lord.
Of Bharatiya. Now, whether a person continues to be a Bharatiya or not, that is covered by the definition. Okay, just like 2G, there is a definition.
My lord.
Here also there is a definition.
Yes, my lord. Bharatiyas will be, it is an inheritable right.
No, whether
the right to occupy as a Bharatiya is an inheritable right.
2G embargo.
2G, you see, just like 2G, the definition of tenant is there.
Yes.
Similarly, in this 2(1)(a), Bharatiya definition is there.
Is there.
Yes.
Okay. Now the question here is this thing, whether all are Bharatiya or not.
And I will place before your lordship.
Yes.
Your lordship has found, my lord, so
now the question, you see, the monthly and periodical tenancies, these are governed by the Premises Tenancy Act. But the forum is the Thika controller.
My lord, that is, my lord, our respectful. I will place before your lordship.
That is the forum is the Thika controller. But when a plaintiff does not admit a Bharatiya as a Bharatiya, okay, the moment he can show that he is a Bharatiya, then the court loses the jurisdiction.
And he himself says that my father was a Bharatiya.
Very well. Now the question is, just like 2G, okay, 2G is very clear. But under the Thika Tenancy Act,
there is no such provision.
No, whether the Bharatiya continues to be a Bharatiya.
Yes, my lord.
No,
even
my
after-
lord. Because, my lord, it matters the payment of Bharatiyas and their eviction of by the Thika tenants, the owners of the structure shall be deemed to be landlords and the Bharatiyas shall be deemed to be tenants under the said act. Under the said act means 1997 act.
Yes,
Actual loss of
Bharatiya.
tenant,
Yes.
Thika tenant would be landlord and Bharatiya would be tenant.
No, right. This is.
Then, my lord,
that-
kindly
that
come to
is
the West Bengal.
881.
8-1.
The question is, what is the 2G is very clear. So you can proceed against a tenant under 2G. But the moment the provisions of the West Bengal Premises Tenancy Act will apply, whatever is there. But the
Then, my lord-
moment a person ceases to be a Bharatiya, okay. If a moment a person ceases to be a Bharatiya, he becomes a trespasser. And that the court is to decide whether a person ceases to be a Bharatiya or not. Now the question is,
My lord, kindly visualize, my lord, what are the prior to enactment of this act, what are the, my lord, the procedure was to be followed. My lord, initially, my lord, the civil code has the power in case of eviction of a Thika property, in case of eviction of a khas property. Now, my lord, after the enactment of this act,
no,
Is that-
because you see one thing, the moment you admit this person as a Bharatiya, okay, the court loses its jurisdiction.
no. My lord, Thika tenant is a landlord.
No, the moment
Bharatiya is
you are
the,
not admitting him as the Bharatiya. That is why you are claiming jurisdiction.
yes.
The moment
Why
you,
I am claiming, my lord, that
Yes.
he is not a Bharatiya.
that's a different issue.
Yes. If
You
I,
see, the moment you claim, this court loses its
yes.
jurisdiction.
If
The
I,
Thika
suppose,
controller has the jurisdiction.
suppose, my lord, visualize in this way, suppose, my lord, I filed a suit against the father of the defendant, father of the present appellant. In that event, my lord, that suit would be a eviction of a Bharatiya. In that event, my lord, I don't
You
have
are
any.
not admitting him to be a Bharatiya. Now the only
Now
question is,
my case is that you are not a Bharatiya after expiry of 5 years from the date of death of your father.
You see, is it same as 2G? That is the
Yes,
thing.
2G. Because section 8.1 says,
Because you are not evicting him under 2G. You have to evict him under
no.
2A. Under 2A, he is a trespasser. You have to show that.
Yes, I am evicting under 2G. Because section 8.1 says that Thika tenant is to be treated as a landlord and my lord, Bharatiya is to be treated as a tenant. Under and
8.1 says.
yes, section 8.1, my lord.
My lord, before my lord, there is a judgment passed by this division bench of this honorable
That is
court which
clear.
have hold.
No, I shall consider all judgments. You
My
see,
lord,
this
it
is the
holds that the
First, it is to be
right
ascertained
of
whether
a
this is a
Bharatiya,
suit or-
yes.
right of a Bharatiya is heritable and partable.
Now
No.
I will
no,
come
no.
across
Now
the
the
judgment
question is, you see, now the
passed by the honorable division bench.
so that
And I haven't.
that for that you see trial of the suit is necessary. Suppose he admits you as a Bharatiya, then from the plaint itself the court does not have jurisdiction.
Yes, but this is not
Thing
my
is
case.
this, he did not admit you as a Bharatiya.
Because you are a trespasser.
Now you have to show.
Sir, I will just try to demonstrate a situation like this. Existence of a family court. In family courts, your lordship knows, in family courts, matrimonial suits are being heard.
Yes.
Governing the same principles which are been decided in a civil court, deciding matrimonial suit. When there is a particular family court has been formed, suppose a suit has been filed under Hindu Marriage Act.
Yes.
It is decided under Hindu Marriage Act. But in a situation where there is no existence of family court, suppose in case of Calcutta jurisdiction, we cannot file any matrimonial suit before any court of law because there is an express bar in the Family Courts Act.
Yes.
Situation is acting like that.
You see, when a statute has conferred a power, has created a forum,
my lord,
the court loses its jurisdiction. That
is section
no,
21.
no. Had it been his case that you are his Bharatiya, the court loses its jurisdiction.
Yes, of course.
Only thing is this, he is not admitting you to
I
be
am
the
a-
Bharatiya, claiming him to be a trespasser. Very well.
Well, that is to be decided.
No. For that a regular trial is necessary. You have to take the plea in your written
This is
statement.
not the case that yes, he died on such and such. He says, I have admitted.
That means
no
you have to state that by in your written statement.
Now, my lord,
You have to take your defense anyway.
Yes.
The court can frame an issue of maintainability.
Of
But
course.
prior to that, let us only ascertain
My lord,
What
these
are the-
judgments I will place, my lord.
What are the rights of the Bharatiya?
My lord, next.
So with regard to Bharatiya, where do you get the definition of Bharatiya?
Yes, Bharatiya gets my lord section 8.1. My lord, visualize in earlier way, my lord, suppose my lord this act has not come into force. Earlier occasion, my lord, what would happen, my lord? Eviction of a tenant from khas property, eviction of a Bharatiya from Thika property, all were triable before the civil court.
Now it is before the controller.
Now it is before the controller. Eviction of a Bharatiya. Now my
Bharatiya is liable to be evicted if there are certain.
if there are certain laws, then now my lord, now my case is that you are a trespasser. I am filed a simplicity civil suit for eviction of a trespasser and also for recovery of possession. First, it is to be ascertained, my lord, whether my suit is not for eviction of a Bharatiya. If my suit is for eviction of a Bharatiya, I will be out of track.
In general law, that is Premises Tenancy Act, if it is suit for eviction of a person under 2G, it is law is very clear.
Yes.
But here there is no 2G. A Bharatiya
2G,
will,
but
if Bharatiya will come under this 1A. Okay.
Yes, my lord. Then, my lord, let me place, my lord, section 8.1 against. The monthly and other periodical tenancies of Bharatiyas in respect of the structures occupied by them on payment of rents to the Thika tenants shall with effect from the date of coming into force of this act be governed by the provisions of the West Bengal Premises Tenancy Act 1997. In the matters relating to the payment of rent by the Bharatiyas and their eviction by the Thika tenants, the owners of the structure shall be deemed to be landlords and the Bharatiyas shall be deemed to be tenants under the said act. Means, my lord, this West Bengal Premises Tenancy Act 1997 will govern in respect of a, my lord, eviction of a Bharatiya.
Oh, shall be deemed to be tenant.
Yes, my lord. In that event, my lord, the tenancy of a Bharatiya upon the date of the Bharatiya, the tenancy continues for a period of 5 years. So, my lord, he loses the, my lord, definition of a tenant and a Bharatiya. And section 2G will apply.
No, is it your specific case that 5 years have
Yes.
passed?
Kindly come to my plain case. Specific, I have categorically stated, my lord, paragraph 6.
Anyway, you see, on this issue, section 8, Bharatiya and 2G, it's not a decision on regular trial, order 7, rule 11. If from the plaintiff itself,
That is, my lord,
if the plaintiff itself had he admitted you as a Bharatiya, suit would have gone, no question. He has not admitted you as a Bharatiya as a licensee. There are decisions that a suit against a trespasser or a licensee is maintainable. Okay, there is no dispute. Only thing is let your learned friend come with decisions. Only thing is you address on these two particular points.
Yes.
Section 8 and Bharatiya and this 2G. Nothing
2G.
else.
My case is 2G.
Very well, 2G you address on this section 8 points.
Yes.
And 2G whether you see that limited period is applicable.
Yes.
And my lord, Ashit Chatterjee, regarding Ashit Chatterjee judgment, I tried to demonstrate that was, my lord,
Anyway,
admission. Ashit Chatterjee is not applicable because the appellate court below have dismissed they allowed the appeal only on the basis of Ashit Chatterjee. Ashit Chatterjee, just a minute. Ashit Chatterjee, there was a full-fledged trial. There was a finding that the defendant.
Unless and until
it's better. It's better you come. The scope is very limited. Point is very limited points of law. Interpretation of section 2G, section 8.1, and the other is this.
Section
unless and until trial is, my lord,
1A. So,
conducted.
So as because he has admitted you, he has alleged that you are a trespasser and not admitted you as a Bharatiya, you cannot say that the suit is barred by law.
So far,
at this stage.
My learned.
So you satisfy on these two particular points. Come with your written notes of arguments and submit and conclude on the next day. Yes. Learned advocates for the parties at present had learned advocates. Let this matter appear for further hearing. Yes, try to conclude it on the next day.
By that time, we will prepare a short.
Yes, short notes and the decisions.
It was a fortnight.
Not 12, my lord. 12 not possible, my lord.
Has to counsel 12. আমাদের কাজ
12 তারিখ অসুবিধা আছে 11 তারিখ দেখুন তো 11
পরের সপ্তাহে দিন না দাদা
না পরের সপ্তাহে হবে না দাদা
কেন হবে না can you keep it on this
let me but 13th 11th second week of February
এই 16 তারিখ দেখুন 16 Yes, 16/2/2026 at 2 p.m.
My lord, item number 6 and 7, my lord, it is fixed at 3 p.m., my lord. Me and this Mr. Amit Ranjan Rai, we have another matter, my lord, before Honorable Justice Ananya Bandapadhyay. In case we cannot come, my lord, will kindly pardon us and make.
Both of you will be there.
Yes, same. There also it's same.
Okay, I shall
In
consider.
case, my lord will kindly make it not to that.
Okay.
Then we'll try to be here, but in case, grateful, my lord.
So grateful, my lord, for giving us it's a very interesting point of law, my lord.
But it will not take much time because the point is it is not a regular trial.
Not a regular trial.
So
because the judgments relied by appellate court is squarely not applying in our case.
yes. Let
That
us
is
see
my
how
lord,
far it is applicable.
grateful, lord.
Lordship, may I be allowed to mention, Lordship, one matter, Lordship? Today morning, Lordship, I have mentioned two matters, Lordship, serial number 89 and 110. Your
Yes.
Lordship was, after hearing me,
Yes.
your Lordship was graciously pleased to appear both this matter in the list of Monday, Lordship.
Yes.
But Lordship, the court officers have not marked this, Lordship.
Anyway, that will be done in course of the day.
But Lordship, both these matter, Lordship, short matter, Lordship. Only, Lordship, income point, Lordship.
Anyway, it
I
will
have,
be done. If it
I
is
have-
not, no, if it is, whatever it is, it will be done. If you have some any doubt, you give the slip once again.
Lordship, much obliged.
আছে কেউ অ্যাপিয়ার করছে? Yes, hence this appeal, FMA 8 of 2024 stands disposed. The judgment and award dated 24th January 2020 passed by learned additional district judge at Mal Jalpaiguri in MSC case number 150 of 2019 stands modified to the extent that the claimant appellant is entitled to rupees 11 lakh from respondent number 1 United India Insurance Company Limited, along with interest at the rate of 6% per annum from the date of filing of the claim case till today. The deposit of 11 lakh along with interest shall be made by respondent number 1 insurance company before the registered circuit bench at Jalpaiguri. In the event the amount awarded by the learned trial judge is deposited, the balance amount shall be deposited before the registered circuit bench at Jalpaiguri. Such deposit shall be made within 8 weeks from the date of communication of this order. The claimant appellant is entitled to withdraw the amount deposited along with accrued interest upon compliance of necessary formalities. Yes, call the.
For the respondent, man.
Yes, you are making your arguments on the last occasion and
Yes.
with regard to the cross-examination
Cross-examine.
of the appellant. What has come?
Your
Proceed on that point only.
lordship made a query whether the documents submitted by the appellant, when exhibited,
Yes,
were marked as opposed to, objected to.
yes.
That is not there.
It is not.
It is not marked as objected to. That's a fact. We have gone through the LCR, and I understand my learned friend has also placed the evidence part before your lordship.
Anyway,
But in
regarding
cross-
what was the cross-examination?
Regarding the documents or the medical prescriptions.
Medical prescriptions, they were marked exhibit without objection.
Without objections, without objected to, but in the cross-examination, those points were taken.
Yes.
Now your lordship will decide what would be the fate of such evidence. But in the cross-examination, if the LCR is placed before your lordship will find that all those questions were put to the witness, who was the appellant himself. But from the LCR, it is found those were not marked as objected to.
Yes.
Now, my lord, the delay in the according to the
What is the
application for
cross-examination put to the appellant regarding this delay? What,
the
what are the
delay,
relevant questions? Give me the-
relevant questions were there, my lord. If the LCR,
May I say in gist, my lord?
Yes.
In the cross-examination, they have asked when he was admitted, which was answered, when the date was specified, when he came to know, that was answered. He was asked whether how he was communicate to his learned lawyer. He specifically stated that Mr. Chase, learned senior advocate there, he over telephone, he has conversation, he had directed him to come and present. Thereafter, he was informed. He was asked about his sister, who is also party in the proceeding. In cross-examination, it was stated that he is more than aged about 80 years and she is ill and bedridden position. This was done.
Date of admission of the hospital was
Yes, there was questioned.
okay, date of admission in hospital was put and that was answered.
That was answered.
And also the discharge.
And also the discharge.
How long was he there in the hospital?
That is the relevant point.
No, was that question put? Date of discharge?
Yes, that was
naturally when the
So date of admission in hospital was put, date of discharge was also put.
Yes.
By way of evidence, the delay is to be sufficiently explained. According to us, my lord, that has not been done. 439 days delay according to their application, but in reality, it is more than that. Now, so far, this appeal is concerned, my lord, two questions has already been framed on which this appeal is going to be heard, but my learned friend has also agitated the point of jurisdiction. Now, if
Anyway,
you all
I'm not going into that. I shall
okay,
confine
then I will not answer to that. I am relying upon a judgment of the Supreme Court, my lord. It was a recent judgment delivered in 2025 on the point of limitation. It take to Devan.
Hey.
This is a voluminous judgment, my lord, quite a big judgment, large judgment.
Yes, I think
But
now the question is there
principles laid down regarding
that the delay from the date of the judgment, not from the date of completion of the period of limitation.
Yes. Apart from that, regarding limitation and condonation, certain principle has been laid down in this, or rather reiterated in this judgment. May I place the head notes? Otherwise, it is a very long judgment, man.
Yes.
May I head note? Head note B. Law of limitation is founded on public policy. Object of limitation is to put a question on stale and dead disputes. A person ought not to be allowed to agitate his claim after a long delay. Rules of limitation are not meant to destroy rights of parties. They are meant to see that parties do not resort to dilatory tactics, but seek their remedy promptly. Object of providing a legal remedy is to repair damage caused by the reason of legal injury. A law of limitation fixes a lifespan for such legal remedy for redress of legal injury so suffered. Unending period for launching remedy may lead to unending uncertainty and consequential anarchy. Idea is that every legal remedy must be kept alive for a legislatively fixed period of time. Dominant objective underlying law of limitation is that any lease cannot be kept in a state of flux or uncertainty. Doubt or suspense, public interest demands that to some point finality be put to litigations. Then C, condonation of delay. Decisive factor is adequacy of cause shown, not length of delay. Phrase of sufficient cause in section 5 of Limitation Act is an expression of elastic import, incapable of precise definition, yet not without boundaries. Its purpose is to empower courts to advance cause of justice by preventing genuine litigants from being shut out on account of unavoidable delays. At the same time, phrase is not a charter for indolence or a device to revive stale claims that law of limitation otherwise extinguishes. Burden to establish sufficient cause lies upon parties seeking condonation. Court must be satisfied that cause is real, bona fide, and free of negligence. Sufficiency of cause is to be determined contextually or totally of circumstances, with due regard to conduct of applicant and prejudice caused to opposite party. Inquiry is not mechanical but principled, resting on dual pillars of bona fide and diligence. Expression sufficient cause must be construed in a manner that advances substantial justice while preserving discipline of limitation. Courts are not to be swayed by sympathy or technical rigidity, but rather by a judicious appraisal of whether applicant acted with reasonable diligence in pursuing the remedy. Where explanation is bona fide, plausible, and consistent with ordinary human conduct, courts have leaned towards condonation. When negligence, want of good faith, or a casual approach is discernible, condonation has been refused. So, in this case also, I say that the appellant was very much negligible in pursuing his own case. D, my lord, no litigant should be permitted to be so lethargic and apathetic, much less be permitted by courts to misuse process of law, unlike a private litigant, where state or any of its instrumentalities happens to be litigant in a lease. Decisions to prefer appeal or file an application is seldom the result of singular will. Rather, it emerges from a collective exercise involving procedure compliance, legal opinion, administrative authorization, and responsible officers bound to rigid protocols and established hierarchies. It was an accepted norm that unavoidable delays would inevitably arise in its litigation, not out of any want of diligence or malafide, but as a byproduct of bureaucratic processes. Unlike in case of private parties, where consequences of dismissal may remain confined to litigants themselves, dismissal of a proceeding initiated by state has a cascading effect, as it directly impacts community whose interest state represents. Adoption of a rigid and uncompromising standard towards state in matters of condonation of delay would, in substance, punish public for delays that are occasioned by systematic and institutional constraints rather than by deliberate inaction or negligence. Condonation of delay is to remain an exception, not the rule. Government litigants, not less than private parties, must demonstrate to bona fide, sufficient, and cogent cause of delay. Absent such justification, delay cannot be condoned merely on ground of identity of applicant. Now here, state is not the appellant or before your lordship. It's between private parties. So negligence is a very vital ingredient in deciding the limitation or condonation of delay. Now, the entire case or the factual matrix of the case indicates the appellant was not diligent. He took everything very casually. Of course, he was admitted in the hospital. That transpires from the court records,
So
LCR.
from the facts of the case, from the age of the parties, from the surrounding circumstances, the court has to infer whether it's a bona fide, act
or
it's a
not.
negligent
Bona fide
act.
or not. This is my argument, Malo, since
And probably this appellant,
since
the died also.
Yes, he has.
What was the age of the appellant at the time of referring the appeal?
In his late 60s.
Late 60s.
60s.
75.
First appeal করার সময়? No, first appeal file করার সময়. In 2008, I suppose the first appeal was filed in 2008. Your lordship's query is
65.
65. Yes, he was admitted in hospital, my lord.
But 65.
Yes.
But he was suffering. Those documents are there. But the question is that the entire...
And sufficiently the matter was heard by the evidence was reduced after considering the evidence, the documents were exhibited without objection.
Now, since there are only 2 points which are to be agitated, my lord, I have nothing more
The
to
length
submit.
of the delay, what was the length of the delay in this matter?
439 days.
No, this
That-
matter, the
Here
Supreme
is
Court
my-
matter.
3,966.
3,966, and this is only 495.
39 days, and that is not correct.
The
495.
application which we decide every day, for this we have to hear out an appeal.
Yes. But my lord, it is the principle which is to be taken into consideration.
3,000 days delay anyway.
Anyway, the consideration is to be the principles.
You have to see how far the facts are applicable here.
Yes. My lord.
So very well, you give your reply and give your better you give your written notes. Nothing to give reply.
I shall distinguish this judgment, my lord.
And
Facts.
you give a distinguish in your written notes. Your learned friend, senior friend has dealt with this judgment. Okay. You come with a short written notes of arguments. You may
My
do
lord.
one thing.
My
You
lord.
can give it this one with your written notes.
My lord.
Two things I should submit, my lord. Two things, my lord. Here, my lord, a delay of 3,966 days, the 2025 judgment. Yesterday, I have supplied a judgment before your lordship. I have given them a copy also, which was more than 2 years, 4 months, did they?
Which case?
Yesterday itself, in this matter only. Why the matter was taken?
Anyway, you better give a compilation.
I shall give
Written notes and compilation.
It is also 2025 judgment where the court says the merit has to be considered, delay has to be liberal approach. It is.
Anyway, this is a two-judge bench.
Yes, yes, 2 years.
Latest judgment, two-judge bench. I think other decisions were taken into consideration.
A lot of judgment has been
There are
relied
other
upon by both the
decisions also.
parties before the court below, my lord, and the learned court below, first appellate court below, relied on such judgments and then on proceeded to pass the order. Be that as it may, since there are only 2 issues which are to be agitated before your lordship, there is
Anyway,
not much
so,
to
so
submit.
better you give it in the compilation with the written notes. Yes, record and order.
By
Learned
which day?
advocates
My
for
lord,
the-
by
I'm keeping a date as to be mentioned for supplying the written notes. Learned advocates for the parties are present. Heard learned advocates. The hearing of arguments is concluded. However, the parties are granted opportunity to file written notes of arguments and the relevant decisions. Let this matter appear on 3/2, 3rd of February.
If I look anything 4th.
Okay. 4/2/2026. আচ্ছা এটা ওটাকে 4 তারিখে দেখুন তো কোনো 4টের সময় কোনো ম্যাটার আছে না অথবা টু বি মেনশনও রেখে দেওয়া
To be mentioned because 4th there is a 10:30 fixed matter before your lordship's court. It will be easy for me also to hand it over. I will be there in the 10:30.
Keep it at 4 p.m.
My lord, 4 p.m. we will, if your lordship has any further query.
4/2/2026.
Better
at 4 p.m.
Kindly keep say 2 p.m. If there is a 3:30, then.
ও তাহলে 5 তারিখে দেখুন
Kindly keep say to be mentioned at
2 p.m.
No, in the morning you will not be able to come.
No, I will be able to come, my lord, but if your lordship has any query, so let it be fixed for at 2 p.m. It won't take more than 10 minutes.
4 তারিখে দুটোই হবে না 5 তারিখে
5 তারিখে দুটো yes দিন
Okay, 6/2/2026 at 4 p.m.
2 p.m. my lord.
2 p.m. will be
Friday, my lord, kindly do not give any in 4 p.m.
তাহলে 10th ইয়েতে করে দিন to be mentioned.
Yes, mentioned. Yes.
6/2/2026 under the heading to be mentioned.
To be mentioned.
Even if the court does not reach that matter, you mention and I shall take it up.
Mal. Grateful, Mal.
People of this.
তাহলে 3টের সময় আবার বলেছে যে যদি না থাকে তাহলে একটু ইয়ে করতে দিন ঠিক আছে
I'm for the appellant one. What the appellant, my lord? My lord,
You're for
yes,
the
I-
appellant insurance company.
I'm for the claimant response.
That's cross subject.
Yes.
My lord, I have filed the appeal mainly on 7 grounds. now. First of all, the age of the deceased was 50 years. The learned tribunal has considered multiplier 13, but my submission is that, my lord, as it was 50, that means 50 has crossed at least 1 second after 50 years, so it should be 11 according to Sarala Bharma. Judgment. Multiplier. Now, my lord,
Okay. So this is the first ground.
yes, according to the judgment, my lord, the multiplier should be, multiplier has been considered as 11, 13, sorry, 13, as the age was 50. According to postmortem report, age was 50, my lord.
Age was 50.
50.
That is not cross, Lordship. If more
I'm-
than
I'm not
50,
Second ground, Ms. Marat, 2 days delay in lodging the FIR. My lord,
Okay, 2 days delay in lodging FIR.
my lord, we
And
examine,
multiplier should be?
our submission is that multiplier should be 11.
Age 50.
Age 50. Because, my lord, your lordship will find that 36, 46 to 50, multiplier 15, for multiplier 13, 46 to 50, and 51 to 55. That means
As per the postmortem, it was 50.
50. So my submission is that, my lord, I will interpret, my lord, in this way, if your lordship, taking your lordship's kind permission, that I will interpret in this way, that in that judgment, intention of the honorable court was that from 50 onward, it will be, the honorable court has considered, my submission is that, my lord, honorable court has considered 50 onward means 50 plus 1, that means 51. 51 means 50 onward.
Up to 50, that means 50 years, 1 day also, it comes there.
yes, yes.
50 years, 1 day, up to 50.
Up
And the
to
next
50.
is 51.
Then, my lord, 50 to 51.
And between 50 to 51.
50 to 51, there is nothing is clearly stated in the table.
Okay, now this is one aspect. The other aspect is this delay.
2 days delay.
And the other?
Manner of the accident was not properly proved. Eyewitness has proved it, but we examined, my lord, the driver of the 2 vehicles were involved, my lord. One is motorcycle, which the victim was weighing the motorcycle, and another is lorry. My lord,
Lorry,
we
it
have
is the
examined-
case that lorry dashed the motorcycle.
Yes, my lord. But, my lord,
Now, what is the findings of the trial judge?
Learned
regarding-
tribunal has considered lorry as the offending vehicle, but we have examined the driver of the lorry.
So,
as
what is that
PCW.
examination?
Yes,
Let us see.
I'm coming, man. Deposition of OPW 1, page 15.
Yes, OPW 1.
Page
Page 15, yes.
Page 15. I am a summoned witness. I was driver by profession at the relevant time on such and such date. I was driving truck number such and such. There is offending truck, my lord. Offending truck number is also, my lord. WB 034223. WB 0324342323. I have my driving license. This is the driving license stands in my name, and I am submitting the same before this lower court along with a photocopy of the same marked simultaneous exhibit A. the original DL returned to the witness after marking the same and keeping the photocopy of the same.
No,
And
it is
that
the
day,
drive.
motorcycle suddenly appeared in
Oh,
front of my...
it is the case of the driver that the motorcycle came in front of the vehicle.
Yes.
And it is the case of the claimant's witness that the vehicle dashed
Yes.
the motorcycle.
On that day, motorcycle...
Moped, Lordship, not
Moped.
motorcycle. Moped, Lordship.
A motorcycle suddenly appeared in front of my vehicle truck and knocked me and fell down. I was on my proper side. I had no fault in my own. And in
That
process,
means the moped came in front of the truck.
yes.
But as per the claimant's case, truck dashed the motorcycle.
And
charge sheet is submitted against the driver of the vehicle.
That sheet I am coming to. I cannot produce any authorization certificate issued by the owner of the vehicle to show that I was driving the said. Not a fact that I was not driving the offending vehicle. I cannot...
Anyway, the charge sheet is against this driver.
Now, my lord.
Okay, so regarding no valid driving license, he had license.
He had stated, but my lord, another thing has happened, my lord. In this case, our...
No, question is, you see, before this driver, have you taken this question that did you have any driving license or any cross-examination?
No, we have, this is our witness, my lord.
No.
We have made the examination in chief.
So there is no question. He has stated, I have my driving license.
Yes, he has stated.
Okay.
So this point is our witness. We cannot contradict it.
No, if is that, yes, that means if he does not have driving license, you have a right to recover.
Yes. And now, my lord, thereafter, OPW2, John Major Nondi, legal manager of our company, he also adduced evidence. And in his evidence, page number 16 of the paper book.
Page 16. Page 17.
Here in my paper book, it is 16.
Anyway, 16.
That fourth paragraph, that during inquiry of the claim case of Joshoda Hawladar, a notice under section 134C of MV Act has been sent to the insured, that is the owner of the vehicle bearing such as such, to supply and or send us vehicle particulars including DL of the driver of the vehicle, but he did not send or supply the copy of DL of the offending vehicle to us. That after thorough inquiry, I found that the driver of the vehicle, number such and such, both the vehicles, had no driving license at that alleged material time.
So you see, this is marked Exhibit A.
Yes, that
without objection.
Yes.
So the question is, with regard to age is one issue.
Another issue is there, my lord, regarding income.
Yes.
Your lordship will find in the judgment also, in the judgment portion. Judgment, page number 18. That page number 18, 19,
18.
20, page number 20.
No, who adduced evidence with regard to income?
Yes, madam. First of all, this person was according to the claim application,
yes,
this deceased, he was an ex-serviceman. And according to
pension holder.
He was pension holder. And second thing is that he was also after retirement, he was engaged in service in hospital, Murshidabad Medical College and Hospital, as security personnel. Now this Murshidabad Medical College and Hospital security person.
After service, he was engaged. He was a retired army person.
Yes.
Yes, Lordship.
Now in Murshidabad Medical College and Hospital, your lordship will find in page number 20, judgment page number 3, running page number 20, paragraph number 3.
Yes.
Paragraph number 2, my
paragraph
number 2. In his deposition, PW1 category stated such and such, I have dashed his vehicle. His father was removed to local hospital. Thereafter, Kolkata, the injured succumbed to the injury. It appears from the victim was aged 50 years at the time of death. He deposed that his father was an ex-army man and he used to earn rupees 10,040 per month as pension and rupees 8,000 per month as security guard. He has submitted and proved Exhibit 6 pension book with ID card of the deceased Ganesh Hawladar. It appears from Exhibit 6 that the deceased works as sepoy in regimental number such and such, other Adar-T regiment. Now thereafter, my lord, Exhibit 7, it appears that deceased used to earn rupees 7,917 per month as payment for security guard while working as Murshidabad Medical College Hospital. Now this 7,917, this amount has been proved by the claimant by bringing witness from Murshidabad Medical College Hospital. There is no doubt about that.
And
But this-
10,040 is the pension.
Yes, my lord, pension, that has not been proved by bringing any person from the pension.
No,
disbursing
pension,
order.
bank account
Bank
was
account
given.
has been given.
What was given? Bank account.
Bank account. Yes, my lord, bank account. Bank account.
Oh, was there anything? No, regarding, you see, pension book is there.
Yes, ma'am. Pension book has been exhibited, but without examining the proper authority, pension disbursing authority.
No, pension book is there. Bank passbook was also there. Pension book with ID.
With ID.
No, is there any cross examination that he was not a retired service personnel?
My lord,
Yes,
kindly, madam,
just a
PW
minute.
1.
3.
7.
That is PW1.
Yes, ma'am. PW1. I have not witnessed. In fact, my father was CBS only.
Okay, I have filed the pension book. It was marked exhibit. He also filed ID card of security guard hospital. Photocopy of salary certificate, State Bank of India.
Not the fact that my father was.
No, not a fact that the documents filed are manufactured. I have indicated the date of my father to the competent authority.
He was examined twice.
Regarding,
It is the my lord. He was examined twice.
this PW1.
PW1. Page number 10 is the second examination. Second time exam. He was recalled, perhaps. Yes,
Written in Bengali.
written in Bengali.
Anyway, chief is written in Bengali.
Yes.
Yes.
So, my lord, these are the points, my lord, upon which.
So two persons were examined. One is the employer where he was subsequently posted.
Yes, by the claimants.
Yes.
And the claimant himself. That means the son.
Regarding accident, there is an eyewitness. PW2.
PW2. But the driver of the vehicle who had direct involvement in the commission of the offense, my lord, he has stated otherwise.
Disowned his liability.
Yes, disowned his denied
So
that.
anyway, your income aspect, the other is delay aspect. And third is this driver disowned the liability.
Yes. That means contributory negligence. It can be termed as contributory negligence also, or negligence on the part of the deceased himself.
So is it your ground that there is a contributory negligence?
Yes, I've taken the ground, madam. Ground number IV 4. Land Tribunal ordered in law, in fact, in passing there without considering the fact that there was contributory negligence on the part of the deceased motorcyclist in happening of the alleged accident.
Not in motorcycle, that's it, moped. Moped has not required license and also not that's it permissible as per Motor Vehicles Act.
If a motor vehicle And if a vehicle which comes under the purview of motor vehicle definition, my lord,
Yes.
it must require registration, driving license, etc.
No, where is issued by? I cannot produce any author. No, regarding this authorization certificate issued by the owner of the vehicle.
My lord,
No, is it your case that the owner of the vehicle did not have any driving license?
driver of the vehicle?
No, no, driver of which vehicle? The offending vehicle?
Driver of the offending vehicle.
Oh, that's a different issue. I thought that this motorcycle driver, the victim,
It's not.
if the motorcycle driver does not have any driving license and nothing, then to some extent.
If your lordship kindly come to the deposition of DW1, page number 16.
DW1. Yes.
Your lordship will find para number 5.
Yes.
That after thorough inquiry, it is the evidence of our legal manager. Through inquiry, I find that the driver of the vehicle number WB58Y,
that is the victim.
Victim's vehicle, and the WB034223 has no valid driving license at the time of the alleged accident. So it has been denied.
Where it is denied?
By this evidence, by adducing this evidence, my lord. The insurance company has denied that the rider of the moped was not holding holding a driving license. That aspect has been denied.
Oh, driving license. You see, during inquiry of the claim case, a notice was sent to the insured owner of the vehicle to supply and send the vehicle particulars, including driving license of the driver of the vehicle. But
he did not send or supply the copy of driving license.
you see, regarding driving license also, the Motor Vehicles Authority can also submit.
Yes,
whether
yes, my lord. It has not been done.
No, suppose a particular person dies, okay, whether he was driving that particular vehicle with driving license or not, okay, because that person, if that person himself is the owner of the vehicle,
Yes.
whether that vehicle, whether any driving license was issued to this person or not, to Mr. X, that inquiry can be caused.
Yes, inquiry could be caused, my lord, by
the insurance companies to go to the Motor Vehicles Authority and ascertain
of that particular area where he used to reside.
Yes, and this vehicle was registered. That is
driving license department and registering authority department, my lord, both are totally separate.
Yes.
And my lord, actually, both the departments have no connection between them.
Yes. So driving license department is there.
There.
Falls within RTA.
Within RTA, yes.
Driving
Within
license
RTO.
and the registering authority are different.
Different.
So driving license department can say whether a particular driving license was issued to a particular person or not.
Whether any driving license was issued
to a particular person or not, and with regard to a particular vehicle also.
Yes.
Because he is obtaining driving license, if he has a vehicle, probably he will give the name of that vehicle.
Yes. That is our laches. That has not been done. Even no attempt has been made so far as the court record is concerned. We have not find that any such attempt was.
Then to some extent, contributory negligence may come. Anyway, so these 3 points: delay in FIR, multiplier, and
income,
and the issue of income,
and contributory negligence,
and the contributory negligence.
Mainly. And to a delay in FIR, delay in lodging FIR.
Yes, that is the first point. Yes. Now, what is your?
They have filed one court, my lord.
Lordship, my cross objection, Lordship, 3 points. First, lordships. No lordships, no future prospect given. The disease was a lordships government employee, retired persons. So his age is 50, then lordship 30 would be multiplied. Future 30% should be considered. But here learned judge is not considered. Second point is lordships consortium 9,000 given. As per lordships, pronoicery judgment lordship, now it is 84,000. 10% is lordship deviation every 3 years increase. So 70,000, and then
So consortium, how much is awarded?
9,000
No, loss of estate.
lordships. 5,000, no lordships. Okay.
2,000 funeral expense, my lord.
Loss of estate, loss of consortium.
2,500 loss of estate.
2,000, 2,500 and 5,000. And all total lordship 5,000 as consortium, loss of estate lordship 2,500 and funeral lordship 2,000.
Total 10,000.
9,500.
Total 9,500 has been allowed.
It 163 application. This is 166. So lordships 70
This is 166.
Yes, lordships. 166, 70,000 as per pronoicery judgment lordship. There after 2017 decision was passed, and thereafter now 2026 lordships in 84,000 more above lordship 10%, 10%. And 30% future prospect. Lordship, my learned friend is stating, now my learned friend appeal I am coming to. Future prospect and consortium. That should be considered.
Future prospect, how much are you claiming? 30%?
30%. His age is lordship 50 years. As per lordship's government
So if
employee.
future prospect, what was this salary taken? Total 17,000.
70,957.
So if 20,000 is also taken, how much it comes?
My lord, I am praying indulgence, my lord, to interfere in this point.
No, you will give you a reply. I'm just clarifying. Suppose taking the future prospect into consideration, rupees 20,000
Yes, Lord,
is taken. So, the
64,000.
learned trial court proceeded on 17,000 something.
Yes, sir.
So, if future prospect is taken and rupees 20,000 is the monthly salary.
Yes. Lordship, I have calculated 17,957.
Yes.
Accordingly, Lordships, within a year, 1 year, Lordship, 64,645. Calculation is that.
My lord,
No, on the basis of this.
one,
Yes.
one thing, my lord, I am
30%,
coming.
30%, Lordship.
One indulgence I am praying, your lordship. That is, my lord, after crossing 50, the future prospect will be, in case of government employees, 15%. In case of others,
Increase of
10%.
pensions and some allowances,
10%.
all these things.
Yes, Lordship.
Future prospect,
Not
it should be.
30%.
Future prospect should be.
In government employees who are in
Yes.
government
After
employment.
50, but Lordship, within 50.
He's 60. He's 60, above 60.
No.
No, 50. No.
According to the
Not
Oh, he prematurely retired.
Lordships.
That means he was getting pension. He's retired employee.
Yes.
Yes, Lordship.
According
That
to-
is a government.
to Sharala Bharma judgment as well as pronunciatory judgment also, my lord, in case of person above 50,
Yes.
after 50 years age, after 40, up to 40 it is 50%, 40 to 50 is 30%,
Yes, Lord.
and above 50 it will be, in case of government employee,
Then
it is
50.
15%, and in case of others,
Then
it
10%.
is 10%.
So that is why for to sum up, okay, to consolidate the matter. Suppose 17,000 something. Suppose instead of that, oh, very well, let it be a consolidated amount of 20,000. So how much it comes? For example, no, 20,000 should be the monthly income.
Because Lordship, his age is not 50 years more. He is within 50
I am
years.
not proceeding on arithmetical accuracy. Just you have to give a just and reasonable compensation.
Lordship.
Suppose you see, let us proceed on that 20,000. 20,000. That means 2,40,000.
Yes, Lordship.
That is one. Then 1/3 should be deducted.
Yes.
1/3. Later I have
80,000.
Yes.
One third is 20.
1/3 is 80.
20,000 into 8 means.
No, 20,000 into 12.
8 means first 2/3.
Okay.
If your lordship multiply it with 8.
1,60,000. 1,60,000. 1,60,000. According to you, the multiplier should be 11.
Yes, ma'am.
No, Lordship. Oh, how it is 11? Oh, his age is not Lordship's 50 years more.
Just a minute. So, according to, if your assumption is taken that 11, it comes to, that means 1,60,000 into 11, it comes to 17,60,000.
Yes.
To that, you may add this thing, 70,000. 40,
yes.
40 plus this thing. It comes to 18,30,000.
Yes.
You see, you can just verify. For example, 2,40,000. Then 1/3 gone, 1,60,000 into 11, as he was very well 11 multiplier, 17,60,000. Then that funeral and consortium and all these things, 70,000.
Not Lordship.
40 plus 30. 40 is consortium.
Lordship 84,000 now to
Very well.
2026 Lordship.
So 70,000. So it comes to 18,30,000. Very well, 18,40,000.
Lordship in this way is not correct. This is law, Lordship.
See, law is just and reasonable compensation.
Then Lordship,
Law is not all.
consider Lordship 70,000 and pronoicity judgment stated. So Lordship, we are bounding upon the Lordship's Honorable Supreme Court. I mean, our court also consider. Your Lordship also considers.
Achha, the interest awarded is 5% per annum.
That is 6%. That should be 6%.
Is that challenged in the court?
Have you stated interest too?
Yes, Lordship. Lordships, here I'll finally have a look at this point. What the learned tribunal cannot, should not have disallowed any bona fide claim or claim of cross objectors for their impugned orders otherwise. And 12%, I have stated also, Lordship.
Para number 6.
If it is not taken, but Lordship, there is a general way, Lordship.
6. Para number 6, my lord, of the court.
In the appeal.
In court, my lord, in the court. Page number 29. Page 29.
Thereafter, I have also stated.
29.
Cannot,
29.
not.
Oh, 12%.
Could not, Lordship, our court.
Ought to have been awarded 12%.
Our court, Lordship,
Okay.
presently 6%.
Now, my lord, one thing, my lord, that whether a pension amount, whether any future prospect is they are entitled to get upon the pension amount.
You see, retired person's case means pension. Okay.
Army retired.
That is why that view is taken. Government 15, because after retirement, hardly there is any scope. Only some pension increases.
Pension also due also increases.
According to that judgment, Honorable Supreme Court's judgment, my lord, the the amount has been allowed, 15% increase amount has been allowed, a loss of future prospect has been allowed in case of age between 50 to 55.
No, up to above 60?
Above 60,
Oh,
there
this
is-
person was 50 to 55.
Yes. So, my lord, here
This
the
person
Honorable
is what,
Supreme Court has
50%?
considered this because the normal age of superannuation is 60.
Yes.
And nevertheless, the Honorable Supreme Court has considered this 50 to 60 as 15%.
No, above 60, is there any consideration for
No,
future?
above 60, there is no question of
No, no,
future
that's
prospect.
65
Oh, above 60, there is no
no
scope.
question of future prospect.
No, maybe, but
So,
during this 50 to 55, you see, by virtue of his experience in the military service, he was working in a particular
yes,
place.
yes, yes.
Now, in that place, had he worked up to 65 also, he could have got something.
Yes.
He could have got. That is why, suppose 17,000, if 15% is taken, how much it comes?
May be permitted to use the calculation.
Yes. That
Lordship, he was a army personnel. Army person cannot, Lordship, job 60%. How it is, Lordship?
no, that 17,000 something. For example, let it be 18,000. Out of 18,000,
80,000.
what should be the 15%? Let us see that.
18,000, 15%. How it is, Lordship? We are 50, aged about 50, not, Lordship, more than 51, Lordship.
2,693.55.
That is 2,000. Anyway, that is why overall I took it up. Overall, I took it 20,000.
Yes. 20,000.
He was how much? 50.
According
Yes.
to
51.
According
So up to 55 is 15%.
up to
Yes,
60,
Lordship.
from 50 to 60, my lord.
15%.
15%
Not
in
50,
case of
50.
government-
51, not 50. 50 above, then, Lordships.
from 50, right from 50 to 60, your lordship will find that in Sarla Bharma judgment, in pronunciation judgment specifically stated that 15% in case of government employee, permanent service, and in other cases, that is
So in case of retired person, it is silent.
it is silent.
Retired person above 60 is silent. But anyway, fact is this person was working in a particular
Yes.
place. Some inference, at best, I can stretch it up to 20,000 maximum.
On 7,000 amount which he was earning, my lord, he is definitely entitled to get 15% because he was again employed in a government hospital. But that I am leaving your lordship, my lord, whether he is entitled to get upon the pension amount or not, that I am leaving upon your lordship. Definitely, after if the DA would be increased, they will also be benefited in retired persons also.
Although it is silent, you see.
Yes, but it is silent.
But here two aspects. That is the pension aspect,
Yes, ma'am.
and the other is he was working in a private
Yes,
company as
private-
security.
Not private company, my lord. It is also a government
Oh,
organization.
government under concern
Yes,
as
ma'am.
security guard.
As security.
Okay.
Deeply organized.
Lordship, I have calculated. Lordship, I have
Well,
shown
well, I'm proceeding on a particular basis, please. Learned advocates for the parties are present. Hard learned advocates for the.
Lordship, here income,
Please,
your
please,
Lordship,
please. I've seen your income, whatever it is, I've seen the evidence. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 31st day of August 2022 passed by learned additional district judge Ghatpur, Barhampur, Murshidabad in MV case number 562 of 2014. Top. The case of the the case ta katun. The respondent number 1 who was a claimant. Respondent number 1, 2, and 3
1, 2, and 3. Yes, Lordship.
who are the claimants in the motor accident claim case have also filed a cross objection, being aggrieved by the judgment and award dated 31st August 2022 passed by the learned trial judge. Stop. Next para. The case of the claimants stroke respondents number 1, 2, and 3 before the learned trial judge may be summed up thus. Likhun. On 11/11/2014 at about 1 p.m., one Ganesh Hawaldar alias Ganesh Chandra Hawaldar was going to his workplace at Barhampur Hospital from Hathinagar by his motorcycle bearing registration number WB-58 capital Y stroke 3044, and when he reached near Monindranagar Green Farm, one truck bearing registration number WB303 stroke 4223 coming from opposite side dashed the said motorcycle. As such, said Ganesh Chandra Hawaldar sustained injuries. Stop. The victim was shifted to Murshidabad Medical College and Hospital, and therefrom he was referred to Kolkata for better treatment. Stop. On 12/4/2014, at about 9:35 p.m., he died at hospital. Stop. The victim used to earn rupees 18,040 per month. Pursuant to the accident, a complaint was made before the police authority and case under section 279/338/304 capital A/427 of the Indian Penal Code was instituted. Stop. The charge sheet was submitted against the driver of the offending vehicle. Stop. Pursuant to the filing of the case, notice was issued upon the opposite parties. Stop. Opposite party stroke appellant ICICI Lombard General Insurance Company Limited contested the case by filing written statement. Stop. Issues were framed and evidence was adduced both by the claimants and opposite party insurance company. Stop. The learned trial judge, by judgment and award dated 31st day of August 2022, disposed the claim case by observing and directing as follows. Hence it is, এইটা quote করে দেবেন, page 22. ঠিক আছে? The appellant ICICI Lombard General Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal, being FMAT 61 of 2023. Stop. The respondents number 1, 2, and 3, being claimants before the learned trial court, being also aggrieved by the judgment and award of the learned trial court, has preferred a cross objection, being COT 2 of 2023, COT 12 of 2023. Heard learned advocates for the appellant insurance company and learned advocate for the respondent number 1, 2, and 3 claimants. Peruse the materials on record. Learned advocate for the appellant insurance company submits that there was 2 days delay in lodging the FIR Thus, the case of the claimants should have been disbelieved. Stop. Learned advocate further submits that the multiplier of 11 should have been applied as because the victim was more than 50 years of age and the learned trial judge erred in applying the multiplier of 13. Stop. Learned advocate also submits that there is contributory negligence on the part of the victim which is not taken into consideration by the learned trial court. Stop. It is submitted that the employer, being the pension authority of the victim, was not examined, but the income was accepted by the learned trial judge. It is also submitted that the driver of the victim did not have any valid driving license. Thus, there is contributory negligence on his part. Stopped. Learned advocate for the respondents number 1, 2, and 3 claimants submit that the learned trial judge erred in not taking into consideration the issue of future prospect and thereby thereby granting compensation which is not just and reasonable. It is further submitted that the learned trial judge erred in not taking into consideration the grant of consortium, which ought to have been 40,000, which ought to have been rupees 40,000, and the amount of general damages ought to have been rupees 84,000. Learned advocate also submits that the compensation awarded should be enhanced.
Interest amount.
Enhanced, and the interest awarded should be 6%.
Lordships.
The interest awarded should be more. With regard to the first submission made by the learned advocate for the appellant regarding the delay of 2 days, this court is of the view that the court is of the view that 2 days delay in lodging the FIR is not fatal. Secondly, it has been held in different judicial decisions that in Indian society, after a person meets with an accident, his family members usually rushes to the hospital and will not have the tendency to go and lodge a complaint. Thus, the delay in lodging the FIR cannot be said to be fatal. Stop. With regard to the examination of the pension authority with regard to the proof of income, this court is of the view that as the claimant has submitted the pension papers, which was exhibited with objection, the non-examination of the pension authority is not fatal. Stop. Moreover, the Motor Accident Claim Tribunal is not a civil court, and the rigid rules of evidence is not applicable in case of Motor Accident Claim Tribunal. Stop. When a document is exhibited with objection, the insurance companies have opportunities to make inquiries as to the genuineness of the document and submit report before the court as to whether it is genuine or not. As the object of the insurance companies is to see that genuine claims are honored and frivolous claims are rejected, it is always open to the insurance companies contesting a claim case to make necessary inquiries with regard to the documents filed by the claimants, more so when the said document is issued by the government authority. As in the instant case, the pension papers are exhibited and no inquiry is made and nothing contrary has come in the cross-examination, the said pension paper has to be accepted in evidence. Stop. With regard to the income which the victim is to earn as a security guard after retirement, the employer of the said concern has deposed and the evidence of the said employer is accepted by the learned trial court. Now, with regard to the issue of contributory negligence, although it is stated by the driver of the offending vehicle that the victims has come in front of the motor vehicle, but considering the fact that the driver himself is an accused person and charge sheet has been submitted against him, and the eyewitnesses has deposed the contrary of rash and negligent driving by the driver of the said motor vehicle, the said witness not being an independent witness, his evidence may not be taken into consideration with regard to rash and negligent driving. As it is pointed out by the learned advocate that necessary inquiry was made by the legal manager of ICICI Lombard GIC Limited, the appellant herein, who found that the driver of the vehicle being WB-58Y/3044 and WB-034223 has no valid driving license at the time of alleged accident, it appears that the driver of the vehicle 58Y/3044 produced the driving license at the time of his examination as a witness, being DW2. However, with regard to WB-034223, it is not clear as to how the inquiry was made by the insurance company, whether the insurance company has called for the members of the family of the victim to ascertain the fact, or the insurance company has made necessary inquiry from the Motor Vehicles Authority License Department regarding valid license of vehicle number WB-03/4223 and the driving license of the victim. This statement cannot be relied upon. With regard to the submission of the learned advocates for the respondent number 1, 2, and 3, that future prospect is not taken into consideration. This court is of the view that considering the age of the victim and the fact that the victim was retired, although a future prospect may be taken into consideration at 15%, it would be just and reasonable to take the future prospect along with the income, along with the last income, and proceed on the consolidated sum of rupees 20,000. Stop. As monthly income of the victim is considered as 20,000, the yearly income comes to rupees 2,40,000. 1/3 should be deducted on account of personal expenditure, and annual dependency loss comes to rupees 1,60,000. Considering the age of the victim and the submission made by the learned advocate for the appellant insurance company, it would be just and reasonable if the multiplier 11 is applied to ascertain the total dependency loss. Hence, by applying the multiplier 11,
Lordship, I am interfering in this. Lordship.
no, I have recorded your submission. Okay. Multiplier of 11, the total dependency loss comes to rupees 17,60,000. Further, the claimants respondents number 1, 2, and 3 are entitled to compensation on account of consortium of rupees 40,000 and annual and loss of estate and funeral expense to the extent of 43,000. Thus, rupees 18,44,000 comes by way of arithmetical calculation. Stop. However, as under the Motor Vehicles Act, the court has power to grant just and reasonable compensation. This court is of the view that in the facts and circumstances of the case, rupees 18 lakh is just and reasonable compensation. Thus, the respondent number 1, 2, and 3 stroke claimants are entitled to a compensation of rupees 18 lakh from the appellant ICICI Lombard. ICICI, what is the
Lombard General Insurance Company.
ICICI Lombard General Insurance Company. The compensation amount shall be paid along with interest at the rate of 6% per annum from date of filing of the claim case till today.
18,000 হলো 18 lakhs কিন্তু এখানে তো 18 lakhs
In the event
67
the amount,
কি করে দাম করে
the appellant insurance company shall deposit the compensation amount before the Registrar General High Court Calcutta within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited,
not deposit, Lordship. My learned friend is not deposited.
so how will there be an order of stay if it is not
My lord,
deposited?
I am saying, my lord, it was time was fixed, my lord. But my lord, the company issued the check when they came to deposit it. It was denied because
Anyway, I'm just making it contingency. In the event the amount already deposited, amount awarded by the learned trial court is already deposited, the balance amount shall be deposited.
Lordship, a certain period, ICICI
8 weeks time I have given.
Lordship, I am telling, Lordship, submitting. Because ICICI company is depositing 1 year, taking time. So, Lordship, if it is not deposit within 8 weeks, then that should be carried on another 2%
If it
interest.
is not deposited, you file the execution case.
Lordship, that is another thing. But
Okay.
in this way, our
Okay, in the event the amount is not deposited, the claimant respondent number 1, 2 and 3 will be entitled to proceed in execution in accordance with law.
Lordship, this is procedure. I make contempt petition, but Lordship, they are doing in such way, Lordship. That's why I am submitting. And our High Court also
Anyway, you see, in all matters, this
is another thing, Lordship. Your Lordship, 11 multiply, learned tribunal judge categorically stated aged about 50 years. Even that is 13. That should be 13. Not, I am not, Lordship, disputing 15% Lordship future perspective. Lordship is, I am happy. But Lordship, 13 multiply, your Lordship reduce.
from 8 lakh, it has come to 18 lakh. Okay.
No, not at all, Lordship. 18 lakhs, 7,000.
No.
That is reduced.
No,
How?
no, earlier, you got 6,29,000 from which now you are getting 18 lakh.
Lordship, 18 lakhs, 67. The Lordship, where?
No. How much you received as per the trial court's order?
18 lakhs, 67.
How much?
18 lakhs, Lordship, last day. Page 21.
Page
21. last.
22. Okay.
Lordship, page. Lordship, that is individual person's Lordship.
Just see how much compensation.
Compensation, Lordship, page 21.
Yes, page 22.
Lordship, page 21, the last portion, kindly have a look. A total 18 lakhs 67,528, and that is divided in 3. That's why 6 lakhs, Lordship.
Okay. Now here you are getting what? 18 lakhs.
18, Lordship. Future
18, no. After taking future prospect, you are getting 18 lakhs.
Lordship.
Earlier future prospect was
Not granted, and also 84,000 also not granted.
Yes. Now, total you are getting 18 lakhs along with 6% interest from the date of filing till
As
date
per
of...
your Lordship.
Yes. 18 lakh from the date of filing till today.
Then Lordship, I make cross objection, and Lordship, learned tribunal judge is considered 18 lakh 67,000 without not considering consortium and also Lordship future prospect. And it's
No, you are.
But Lordship, I'm Lordship's learned tribunal, that page 20, kindly have a look, page 20, categorically stated his age is 50 years. If it is within 50 years, that should be Lordship 13. More than 50, Lordship, page 20, para 7, second Lordship. I am from the PM report, exhibit 4, it appears that the victim was aged about
Anyway, in
50 years. Then Lordship,
his appeal, okay, it was his appeal. You have got a reasonable.
Lordship, I am suffering. My Lordship, my husband was Lordship ex-army, and Lordship, since then, they are not Lordship deposited the amount. They are conduct Lordships. Your Lordship considering in insurance company. Lordship, I have lost. I was Lordship. My husband was ex-army personnel, and Lordship, it is granted 50 years he has on job. Thereafter is not granted. It's 60 years.
The amount at present is not deposited.
Not.
That has not been deposited.
It is hereby made clear that in the event the amount
Lordship,
is
13
not,
should be multiplied.
amount is not deposited within 8 weeks, the claimants will be entitled to a further interest, entitled to an interest of 9% per annum from the date of default.
My lord, immediate server copy.
But Lordship, 13 should be considered. That also Lordship reduce. 11 Lordship, how it is justified, Lordship? The age is 50
Okay,
years.
then I do one thing. Instead of 18 lakh, let it be as per the arithmetical calculation, whatever is there.
Lordship.
Acha. Comes the total compensation, কত এসছে বলুন তো? না, তার আগে arithmetical calculation.
না, তার
Okay, 18,44,000, ঠিক আছে? So, ওখানে 18 লাখের জায়গায় 18,44,000 করে দিন। Along with 6% interest from the date of filing till date of deposit. আর ওইটা additional interest. So 18,44,000.
Immediate server copy, my lord.
Yes.
If I get it
tomorrow, it will be
by
made
tomorrow.
in the
Deeply. I will tomorrow. I will come to communicate.
In our, I have also several appeal on the ground in 50 years and that should be a lot. There is a judgment. I will place that in another case. Day after
Yes, next case. Next case, you are ready?
Yes.
Oh, sorry.
6 and 7.
6 is my appeal, my lord. I have preferred this appeal on the ground of route permit, and I've given my written notes also in the matter. My lord will kindly just see it once, and also the quantum, my lord, that 88,000 has been awarded on the head of parental consortium. The claimants are the widow, son, and daughter. So this is I pray before my lord that the 88,000 that should reduce, and my lord will also grant me the liberty to recover from the owner of the vehicle, my lord. Regarding the route permit, in my written notes I have annexed one judgment, which is the recent observation of Supreme Court, my lord, K. Nagendra. K. Huh? No, আপনার তো ব্যাপার নেই, দাঁড়ান না। So I'm praying for pay and recovery, my lord, because at the relevant point of time, my lord, the vehicle did not have a. It had a route permit, but it was traveling at a different place. It was not traveling at the specific place wherein for which the permit was issued. My lord will kindly come to.
The appeal preferred by the insurance company, unless I have prepared the paper book that the documents which the appellant is relying, that is available in the record. Let's kindly use the record where from let's will find the documents where appellant is submitting. The record একবার দিবেন?
It is illegible.
Which copy, lordship?
The
record
LCR. My lord.
paper book দেবেন?
We had adduced one OPW1, my lord. He is the employee of RTO. He deposed before the learned tribunal, my lord, and he exhibited the route permit of the offending vehicle. That is exhibit C. So those exhibits are in the
Let's kindly see the record.
Lower court records, my lord. Trial court records. I am sorry. The evidence of OPW1, my lord.
First part.
The evidence of OPW1, my lord, that is also in the TCR. It's not part of the paperwork, it's there in the TCR.
Evidence.
যেটা আপনি আমাকে দিলেন OPW1 এখানে আছে, পেপার বুকে আছে?
না না না
না, সেটাই তো বললাম।
কপিটা কোথায় গেল?
আপনাদের দিলাম তো ওখানে।
আর ওখান থেকে তোকে দিলাম আমি তো দিলাম তো একটা Unless you got it, OP number.
Let me see. These are the issues.
Uttam Modi.
Yes, this is the depositions.
Yes.
OPW1.
OPW2, no.
OPW1.
So in the paper book, it is not there.
No, it was not part of
available with us.
And the exhibited documents are also in the TCR, my lord.
এটা তো হবে না তো, এটা তো কোর্টের কাগজ। এভিডেন্স page 8 9 কোথায়? হ্যাঁ, ওটার মধ্যে এক্সিবিটটা আছে।
হ্যাঁ, সাক্ষী তো দেখেছেন, সাক্ষী দেখে নিয়েছে।
হুম।
Yes.
একবার ওইটা দাও, ওটার মধ্যে সাক্ষীটা আমি এক্সিবিটটা দেখে দিই।
That is okay.
The vehicle had permit to drive from Jamna to Borbotia,
Question is
my lord.
valid driving license.
Yes, license, there is no issue.
Valid permit also there is there.
Permit was there, but it was not for the place wherein the accident took place, my lord. It had permit to travel from Jamna to Borbotia.
Where is that?
That is the evidence of my lord will kindly see exhibit C. Exhibit
C.
The exhibits are here in this one.
No, this point was argued before the trial court.
Yes, we gave evidence, my lord. OPW1 evidence is there.
Document was made.
Must be, because our evidence is there, my lord.
So what is the discussion of the learned trial judge on this?
I'm coming to that, my lord.
Let me see. This is
Yes, sir.
this is OPW1.
Let us
see exhibit B.
Discussion page 71.
Okay, exhibit B. Let me see this.
কেন
Exhibit এগুলো তো ক্লেমেন্টের এক্সিবিট। এক্সপার আইডেন্টিফিকেশন এগুলো কি দেখি এখানে ক্লেমেন্টের আছে আর এটা আছে।
এটা বার্থ সার্টিফিকেট, ড্রাইভিং লাইসেন্স।
এখানে ক্লেমেন্টের আছে ওর মধ্যে।
Exhibit C is the register of permits.
Yes.
Permits, yes, that is the one.
That is the copy also. That is the copy.
May I just see it once, my lord?
You want to see this?
No, has my lord found it, the route?
Basically, allow us to will assist. This is a folded page.
The permit and the driving license.
My lord will kindly come to page 72 of the paper book that it's discussed. Learned tribunal judge has discussed.
72.
72, my lord, second paragraph.
Yes.
He has argued further that at the relevant time, the offending vehicle was plying through the route not authorized under the route permit. According to him, the insurance company cannot be thus held liable to pay compensation. Exhibit C is the route permit of the offending vehicle duly proved by the OPW1. Exhibit C indicates that the authorized route for the offending vehicle was from Jamna to Borbotia at the relevant time. The accident occurred near Mahavir petrol pump at south side of Kharagpur. Though this point has been raised in written complaint, but nowhere in the entire case, the insurance company has dared to raise this issue. Only upon the basis of written complaint, the insurance company has cited the
Written complaint was that place of accident was mentioned in the written complaint.
yes, maybe that is what the trial judge, maybe that is what he means.
Permit was this place?
It was not for, my main contention is it was not for the place of,
No, the place of accident does not fall within.
yes, this is my main contention. And that is what we tried to prove through the evidence of OPW1. And that is what OPW1 proved. So as
Permit is from this X to
yes,
Y.
yes, but the place of accident, that doesn't fall within this route permit.
না না had valid route permit বলছো তো
সেটাই ওনাকে বলা
Flying
হচ্ছে।
through a route, not
Yes, this place of accident, it did not fall within the valid route permit. It was elsewhere. So obviously this vehicle, it was being driven at a route for which it did not have the valid route permit.
Okay, because it is not the case. That means he had route permit.
He had, but still the policy conditions were violated because
That means if he violates the condition of route permit,
yes,
this is the policy condition.
yes,
Route permit and driving license must be there.
must be there,
Valid driving
and he
license,
also has to ply within that route.
yes, sir. So that is the policy. Condition.
Yes.
Which page? That is the policy.
That is statute.
Oh, which page? Policy condition.
The conditions policy is at page 52, 53,
52.
But this is specifically, it may not be in the certificate of insurance policy. But under Motor Vehicle Act, my lord will see.
There is a violation of the condition, so that condition must be in the policy.
Yes, it is in the policy wordings,
So that
not in the certificate. The certificate was exhibited.
Yes. Driver's clause, a person including insured, provided that a person holds effective driving license and is not disqualified. Okay, this is driver's clause.
এখানে 148 হয়ে গেছে দাদা। The cover number এখানে 147. My lord will kindly see Motor Vehicles Act section 147, my lord, requirement of policy and
In motor vehicle sector আছে এখানে?
and limits of liability. And in the new act, it is, I'm sorry, my lord, in the new act, my lord, it's section 150. And in the old one, my lord, 149(2). My lord will kindly see 149(2) C. Or 150, if my lord is seeing the new book, then 152 C. It, may I read, my lord? The specific word.
One.
My lord?
Are you reading the old?
Yes, I'm reading the old one, my lord. 149(2), my lord, no sum shall be payable by an insurer under subsection 1 in respect of any judgment or award unless then some of the conditions had been laid down. Then I straightway go to that 149(C), my lord, for a purpose not allowed by the permit under which the vehicle is used, comma, where the vehicle is a transport vehicle or. So this is the condition. And this, it was a trekker, my lord, this vehicle. So it's under the statute, my lord. And this, there are other conditions also, my lord, which is maybe it's applicable in other appeals, my lord, for hire and reward, for organized racing and speed testing. But this C, my lord, it's specific. Has my lord found it? Grateful, my lord.
Okay, continue tomorrow or day after tomorrow.
And I have just one minute.
My humble submission is
My
that we
appeal.
have to,
No.
Plus, you kindly say he is a pay and recover. I am for the claimant. I have no submission. And
not
I did
letting
not,
me finish.
I did not place any.
Okay, record an order.
Lordship, kindly make it.
There's one issue, my lord, that 88,000 is there. Initially, I had the notion that my learned friend, that 88,000 consortium, my lord, that issue is there.
And Lordship,
So,
kindly consider this.
All this will be hard. Learned advocates for the parties are present. Hard learned advocates. Let this matter.
then on Monday,
দেখুন তো 4টের সময় কোন দিনে দেওয়া যায়?
no, not 4 p.m., my lord. Then 3:30, most of the days, my lord knows that 2 o'clock.
Usually 3:30 at present it is on Fridays.
No,
No,
Lordship.
no, no.
90% of
আমাদের
the
কোনো
3:30
ঠিকানা
is
নেই।
on Friday.
Tomorrow is
আমাদের
Friday.
কোনো ঠিকানা নেই।
So because you see all the whenever they receive information about 1 month ago or 2 months ago, whatever it is, they keep it on every Fridays.
That is
Here it was immediately they receive information on
Yes,
the
yes,
following day it was held.
yes, yes.
Now
That
they
is
don't
that
hold
is
it today.
that is there, but
Information is if they don't hold tomorrow.
but
Till Friday.
Lordship, apart from the all, can I make it 2 p.m.? If chronological Lordship will take up, we will wait.
আচ্ছা দেখুন তো দুটোর সময় কবে করা যায়? নইলে একটার সময় দেখুন কোন ডেটে ইয়ে করা যায় কিনা।
ভালো।
my written notes, it's already there on record, my lord. Can
রিটেন নোটস দেবে আর বেশি করে
It's-
Basically, I have no submission.
15-20 মিনিটে হয়ে যাবে।
Basically, I have no submission.
Huh?
I have no submission.
কত তারিখে কটায়? 3টে সময়। Yes, let this matter be fixed for final arguments on 6/2/2026
my lord.
at 3 p.m.
3 p.m.
Anyway, it will not take more than 10-15
Only if that consortium issue is
My Lordship,
consortium issue has to be taken into consideration.
my lord, I am deeply obliged.
Lordship, my
I'm deeply
humble
obliged.
submission is that if he convince the court, Lordship will if ultimately directed to pay and recover, then I have no submission. But only the consortium. So whatever Lordship will decide. Because of so Lordship can also make it for judgment. I have no objection.
So, how without hearing at length on all points,
No,
how
but
can
all these only is that
your learned friend will submit that relevant decisions and written notes also.
My learned senior will be submitting on that consortium issue, that same consortium.
No. As a whole, you give us short.
I've already given my written notes.
Decision is there, you give that.
My lord, grateful, my lord, deeply obliged.
Yeah, खत्म कर देता